matters shown, then have it on 27th or 29th. 29th July.
That's similar prayer for admission, man.
29th.
May be your but I will also for listing my probably the personal benefits.
29th July.
Problem.
May I please also? I'd like to mention item number 8 and for a petition on I've taken consent from the
Item number
8.
8.
Paper possible for that.
Item number 8 on the request made by the council for the respondent stands passed over for the day.
Deeply over.
You submitted that consent on the. You are for the petitioner.
Yes, yes. I'm for
For the petitioner stands passed over.
deeply over.
Lordship, therefore listing Lordship one writ petition Lordship. The matter was last listed on 27/10/25 Lordship.
Fifth of August. 5 August.
May I please? Sir, Victor mention item number 12. So, the concern of the advance matter must be adjourned.
You are for the
I'm for the petitioner.
on the council, the request made by the council for the petitioner and matter stands referred to be listed after.
Lordship, there is
Item
urgency. Kindly fix it on Thursday. Lordship.
13.
Thursday on. Lordship,
See, if there's urgency, why you're making a mention today?
there is some difficulty of my senior. Lordship.
Oh, then
There's
we don't fix matters like that.
Lordship, kindly on Thursday.
Not Thursday.
Because
not
the
Thursday. No,
this guy is
Thursday.
the minor who.
We are ready to take up today if you want to do it, or otherwise it goes after 2 weeks.
And on Monday, Lordship.
Not on Monday, after 2 weeks.
On 28th of
2 weeks, 2 weeks. Yes.
I'm praying for listing some admission matter, but
Admission,
yes, but admission matter.
10th of August.
Okay.
Submissions made by the council petitioner that the petition is buttressed.
Not in fact, sure, it is withdrawn. My instruction to withdraw the case.
Does not submission that the writ petition does not wish to press the petition any further. Accordingly, the petition stands dismissed. Is not pressed. In order stand vacated pending either also dismissed.
For withdrawal, item 19. Same order.
Same order.
Hello. Item 1.
So we will take up the item number 2 Lordship.
Item 2.
Same matter Lordship. Here let's the grievance of the petitioner is that Lordship they are the holders of 18-month DLED diploma in elementary education Lordship. Then the advertisement issued in 2024. We have participated in the selection process. Subsequently, an impugn order is issued whereby it is stated that an 18-month diploma is not eligible for appointment. That's why we are.
You are serving teachers.
Yes, we are serving teachers in private school. So we have pursued the diploma within the validity period of 2017 and 19, 14-month diploma. And
Where-
finally,
Under what provision was this diploma?
under the NCT Act Lordship, the 2010 notification.
We don't know where is it available here.
Yes, yes.
Huh.
2003 notification is there.
Page number.
Page number. Annexer Lordship 6, page 84 to 890. Page 84 to 90.
84 to 90.
Lordship. Legal portion Lordship type copy. 84 annexes Lordship 1 minimum qualification. This is the notification whereby NCT prescribed the qualification. We have for elementary school LP, that is class 1 to 5.
1 to 5.
Yes, Lordship, kindly see the minimum qualification in class 1 to 5. What are those qualifications? Senior secondary, that is higher secondary, and 2-year diploma in elementary education.
Okay.
Now, Lordship, after this apex code decision Lordship in this honor, I have Lordship. This issue has already been decided by the Honorable Court and as that order that Lordship find at page 250
No. Tell
Lord.
us in fact that
Lord.
this is the requirement.
requirement.
2 years.
2 years,
Would be 24 months.
24 months,
But you have undergone 18 months.
18 months.
Under what provision?
Lordship, they have relaxed, but the NCT Lordship, although after the RT Act of 2009 Lordship, this qualification has been prescribed, that within the period of 5 years, we have to acquire this
Where
qualification.
is that notification?
That notification, the RT Act itself, what I have stated in the para, '73, no? Yes, NXR 3, page 73, Lordship. The minimum qualification for a person. No. 5 years, within 5 years. Yes, stated in the para. Yes. Lordship, in page number, Lordship, kindly come to page number 22. Page number 22. Here, this is the notification issued by the NCT 28/2017.
Wait.
28/2017 bill which led to the enactment of the right of children to free and compulsory education amendment act 2017. That 2009 act is amended, was passed by the parliament to the RT Act, and so the outer limit of time for the acquisition of minimum qualification.
No, page number 22.
Page number, no, sorry, oh yes, no, 20. 20 Lordship,
20.
20.
Yes.
So after amendment of the RT Act Lordship in 2017, the outer limit was given for the acquisition of minimum qualification by teachers was fixed on 31/3/2019.
No, but where does it say that you will be entitled to undergo only 18 months for serving teachers? Where are the notifications? Anyway, so what is your prayer now?
Now our prayer is that already, although this impure order is issued on 2/1/2024.
Where is that impure?
Page 62 Lordship.
62.
Yes. Page 62. This has been issued after the advertisement. May I read, Lordship?
Yes.
It is for the information of all concerned that the Director of Elementary Education Assam has published advertisement A and advertisement B. Next page, Lordship, page 58. For the recruitment of teachers in LP and ME schools, we are for LP schools.
Page
That-
62.
Page 62, Annexure 1C.
1.
The impugn order 2/1/2024.
2/1/24. Yes.
The advertisements were prepared and published in compliance with the orders passed by the Honorable Supreme Court of India, ordered so and so, wherein it is stated that the qualification of 18-month diploma in elementary education acquired from National Institute of Open Schooling is no longer a valid qualification to be eligible for fresh recruitment to the post of teachers. And this has approval of the government of so and so. All other terms and conditions of the advertisement mentioned above will remain the same. Now, Lordship, the apex court, Lordship, in Vishwanath judgment, in the apex court, in Vishwanath judgment, it has been, Lordship, clarified that there is a mention, Lordship. Lordship, may kindly come to page 253. In the order it is quoted. First, second, third, from fourth paragraph. It also referred to the order of the Honorable Supreme Court in the case of Vishwanath and others, State of Uttarakhand in the review petition so and so, I had ordered dated 10/12/2024, whereby the Honorable Supreme Court has clarified with regard to 18-month DLED obtained from National Institute of Offense Schooling. The relevant paragraph are quoted herein below. So relying on this order, Lordship, the State Department also, Lordship, submitted that the 18-month degree is now recognized. Next page,
Is
18-month diploma is recognized.
recognized.
Page 254.
54.
254, the second paragraph. Today, Mr. So-and-so, Standing Council submits that in view of the clarificatory order by the Honorable Supreme Court in the case of Vishwanath Shukra, although the notice dated 2/1/2024 was issued pursuant to the advertisement issued before the order of the Supreme Court, by now, the 18-month diploma in elementary education acquired by the petitioners will be recognized. Now, our apprehension is that, Lordship, since we have issued this, we have already applied, our cases may not be considered, Lordship, because we are also getting the 18-month diploma. But after this order, Lordship, ultimately this Honorable Court held that the last paragraph, it is made clear that in view of the order dated 10/12/2024 of the Honorable Supreme Court, the impugn notice 2/1/2024 shall not have any effect. So this order may also be passed in this order.
What do you say?
Can it be on Thursday, Malala? I'll satisfy your lordship.
It is noted.
No, Malala, I need some time, Malala.
Last occasion,
Thursday, Malala.
occasion also they have submitted, already the application order is there. And they themselves submitted, it will now be recognized.
Notice has not been issued.
Now this, that is why the last occasion they are directed to obtain instruction.
Let him obtain instructions and tell us what is there.
Well, in the meantime, notice me also.
Huh?
Also notice
Okay,
me.
if we issue notice, then why should we fix it on Thursday?
Otherwise, my lordship may fix on Thursday. I'll satisfy.
As per the last order, you're supposed to
Bring instruction.
obtain instruction.
My lord, I have not received my.
No, there also instruction is here also, page 254. They themselves said that it is to be recognized. Let's just say the 18-month, the second paragraph. After this Vishwanath judgment,
You have completed 18 months.
yes, we have participated. Now our every
participated where?
in the selection process, pursuant to this advertisement.
Your
Because advertisement,
applications are accepted.
yes, yes.
You have highlighted.
That accepted application is lordship will find at page number.
No, but Supreme Court said
Yes. Supreme Court clarified that.
Teachers who are in employment on 10/8/2017.
Yes, we are prior to that.
You are also in employment.
Employment, irrespective of private or public lordship.
And you have completed 18 months.
18 months. We have our forms are accepted. Online, I have applied. That lordship will find that acceptance notice at page 247. It is pending now. The selection process is now under consideration. Page 247 is their acknowledgement. Annexure 19. 247, 249, two petitioners here in there.
And what is this appeal in the first matter? There is a writ appeal. 345.
This appeal, my lord, separate prevention was directed to file.
You can verify. Something they have verified.
No, who filed the appeal?
Similarly situated prisoner lordship.
Why did they file the appeal? Against what order? Which order are they challenging?
Lordship page first page number. Lordship kindly have the first petition at page 155, challenging such notification and futility of the same. A repetition was filed by number so mounting the charge that such a demand
So
for
that notification dated 2/4.
2/4.
Which notification? No, this is 17/6/25. There are certain notification issued for examination, physical verification of additional documents.
Ultimately, we have supplied this document. So that is why they are not verified. The last occasion, they also submitted that state respondent in matter. is
You
under
might go through
consideration.
and give us your instructions, but on Thursday,
My lord,
we make it clear that if there are no instructions coming, we are disposing of the matter. Heard Mr. A. Dekha, learned counsel to the petitioner, and Mr.
Yes,
S.
PK Boram,
Bora for
respondent number 1 and 2.
respondent number 1 and 2. MS RB Bora for 5. And
Respondent number 4, LCT, my lord.
Mr. So and so on behalf of Mr. Ayalam for respondent number 4. In both the petitions. In terms of the earlier order dated 26/6/2026, the respondent, state respondent was supposed to complete their instructions in the matter. Today, when the matter is listed, pre-listed, the prayer for further time is renewed. However, state respondent submits that he completed the instructions by 16th. Accordingly, as agreed to, both the matters be listed for motion on 16th.
It's a failing which their observation may be.
In the event, the state respondent does not apprise the court. In the event the state government fails to obtain required instructions, appropriate orders will be passed by.
Development.
Both the cases I am for respondent number 5.
Huh?
Both the cases I am for respondent number 5.
Yes. Have you received extra copies?
Extra copy is not this.
Huh?
Extra copy.
Today? First half.
Not.
Extra
Problem.
copies, if not already furnished, will be furnished in the course of the day.
Apply.
Instruction to withdraw this,
IA,
the whole petition as well as that.
MSSB Chaudhary, learned counsel to the petitioner, submits all instructions. The writ petitioner does not wish to press the IA as along with the writ petitions any further. Accordingly, the WPC number 2800 stands dismissed as not pressed, as withdrawn. Interim orders have been stand vacated. IA number 2075 of 26 and 2087 of 26 are also dismissed as not pressed. Mr. R.K. Tovildar appears. A.R. Tovildar appears for
Respondent,
all the respondents.
higher education department.
Higher education.
KK Medic for respondent number 5.
A.K. Medi for respondent 5. Mr. Solia for
7. Respondent number 7.
respondent 7.
My lord, the liberty will be taken.
We don't know why you have withdrawn it. Why have you
My
withdrawn?
lord, he has just, I received instruction over telephone, my lord.
Then
So, my lord.
has he asked you for praying for liberty?
Yes, my lord.
Why? Did you not ask him why you want liberty? Here, there is a matter pending. The
Maybe some
petitioner seeks-
discussion is going on.
Huh?
Maybe some discussion is going
we
on.
don't know, but unless you satisfy the court that you are entitled to be granted a liberty, will not grant you liberty. If it is a fresh cause of action, you don't need liberty.
Then I will be allowed to take instruction, my lord.
We have already passed orders. Why is he withdrawn without and then asking for a liberty for what purpose?
Maybe, my lord, he has approached the authorities and they have.
You are the counsel, you don't know,
Just now I received instruction.
right? So we are not your fault, but the client has not expressed why liberty is required. Therefore, we are not good. Right?
Fresh cause of action arises.
Fresh cause of action, no liberty is necessary.
Yes.
And in this case, I'm paying for some more accommodation matter to file our application. Sometime.
Right, with your lordship. This matter relates to refund of excess royal. She was serving as a head teacher of an LP school, your lordship. But the Supreme Court judgment of Rafiq Mukti, your lordship, since he has already retired, your lordship, and he belongs to a class C employee, grade 3. That refund is not permissible. And even otherwise, there is no misrepresentation on her part. It was due to some bona fide mistake, your lordship. She continued and she discharged her service till the order of retirement was issued to her.
Where is the order of retirement?
This is the issued order, lordship would find at page number 27, Annex 7.
You produce the service record.
Service record I have also annexed as
Where?
part of the service record, service book at page number 19. Type copy and 19A. In the service record, it is correctly recorded. Her date of birth is correctly recorded as 19/1/1960. And even she has not made any application that her date of birth would be changed at any point of time. But somehow, the page 19A is the original Xerox copy of the service.
She was the head teacher.
Yes.
LP school, your lordship. Yes.
But she's not an illiterate lady.
Then
She knew that this is her date of entry and her date of exit from service will be in 22, is it?
Yes.
So you overstayed. You return back the money or get it adjusted from your pension.
No, otherwise, your lordship. That service book it is correctly recorded, your lordship. Then it is for
The
the
service book contains the signature of the employee, page number 19A,
yes.
with all these particulars. Means she's aware that this is her correct date of birth.
In the meantime, what happened here, lordship? She obtained a certificate from her LP school, where from it has come out that her date of birth is 1965. On the strength of that, she had changed her PAN card and other card. But in the service record, she has not made any application for change also.
Then?
And she has not made any misrepresentation also. So she was under a bona fide impression that the
How can it be bona fide when all your documents are corrected, but your service book, you signed it and it is shown to be 19/162? Where is the question of bona fide?
when otherwise
And how did you get a copy of the service book?
they have provided from the office she has collected.
Huh?
From the office, I think she.
That's
I don't know.
right.
I don't know from where she has collected, but I have copies.
So therefore, it appears that the petitioner was aware that her date of birth is such and such date and she has to retire on 22. How can there be a bona fide mistake or bona fide belief?
There had been some.
Where is that certificate that she has collected?
Lordship will find at page number 21.
And she did not make any application seeking correction of her date of
No.
birth. Then that
did
is
not
the end
make
of the matter. What else is required? What else?
As per my instruction, he did not make. Only class 10 pass, your lordship.
Huh?
She is a class 10 pass. At that time, class 10 was the requirement. And then I said, very your lordship, belonging to class 3, class C, group 3, grade 3 employee.
Where do you say grade 3? Under the rules. Show us.
Assistant teacher,
Rules.
assistant teacher of an LP school, your lordship.
Under what rules?
Some next Monday. Sorry, Monday or Tuesday, any date next week.
list on 29th July, enabling the respondents to complete their instructions.
Fine. Keep clear.
Obliged.
Here we have received instruction. Here petitioner as per his praise claiming for under section all act that is 2011 act is not in force, my lord. So let us file our affidavit, my lord.
None appears for the petitioner on call. Notice in the matter was issued on 22/5/26. Mr. Bora, learned counsel for the elementary
My lord.
education submits that his instructions are complete. We would like to file necessary affidavit accordingly. Matter stands deferred, listed after 4 weeks.
Published.
Yes.
I'm finally required to find the affidavit. We have not received the instruction, Lord.
The matter is about, we are the guest faculties of Gauhati Engineering College, Your Lordship. We are appointed for a part-time basis. We are released on 11/3/2025. There's not much in there, Your Lordship. We are only seeking the monthly arrear salary of February 2025 and 11 days of March. That's all, Your Lordship. They can calculate it and give it. Not much.
Instruction is required, Lord. Otherwise, it's up on my part.
How much time do you want?
2 weeks in the file affidavit.
Huh?
2 weeks, nothing.
No, instructions and filing affidavit are two things.
I will file
Their
affidavit.
prayer
Lord.
is that they're entitled to the salary which they claim.
Yes,
If
they
they've
are.
worked, then they're
Yes.
entitled to it.
We'll file affidavit, we'll bring, I will regard their, that's it, please. Stand.
Mr.
T.
Chetri, APS for the petition, Mr. Govinda.
Correspondent number 1, 3, and 4. Lord.
Respondents 1, 3, and 4.
1, 3, and
Mr. Solia for respondent
5.
2 and 5. Mr. Govinda submits that instructions are awaited. He brings for further 2 weeks' time. Release this matter again after 2 weeks. Yes.
My pleasure. Arrear salary for a period from 18 to 2014 to 28 to 2015. The total amount was
Yes.
73.
Why not paid?
Yes, my lord. We have filed our affidavit here, my lord.
Affidavit.
And my lord, here's some delay, and the director has calculated the amount, and as per that calculation, 18 to 2014 to 28 to 2015, the salary amount, area and principal amount is 2,73,417. And as he was delayed, so interest at the rate of 7% was calculated from 1/7/2017 to 4/5/2026, as because he instituted a case on 2018. So my lord, it is calculated from 1/7/2017 to 4/5/2026, rupees 1,69,222, and total 4,42,639, and has already been submitted. That proposal has already been submitted to the government, my lord. Now it is pending on the government. My
The
lord.
government means the secondary education.
Yes, my lord, secondary.
So you get the instructions why it is pending before the government.
They have filed affidavit, my lords. And they are now the only dispute issue is that the
You are agreeable.
respondents-
You are agreeable to this amount of 4,40,000.
No, no, that is one of the points. So they have calculated the I am seeking interest at the rate of 10%.
Oh, principal amount is this. Is there any
Yes,
difference?
yes, I agree with the
You
principal
agree?
amount, yes.
Right, now the question is interest
Interest.
is something else you will look into it, but this is the principal amount.
Yes.
Yes.
Say, when was it sent?
It is calculated from 18 to 2020.
No, when was it sent to the?
It is
Secretary's
sent on
office?
6/5/2026.
So get the instructions from the secretary's office. Why? What is the status?
Check. Yes, yes,
They'll have to sanction this amount.
yes.
Yes, it is awaited for sanction.
So proposal has been sent to the
So
government.
proposal will have to be accepted, sanction
yes.
will have to be issued.
Yes, yes, yes.
Yes, Mr. Cholia?
Yes.
Anything from the finance?
No, Lordship, because for area salary, now the
Yes.
budget session is going on, so they'll have a specific budget for area salary. If there's shortfall only, then
Please get instructions next week.
Yes, ma'am.
Next
My lord,
week?
yes, the budget session is going on, my lord, so my lord. it may take
No,
some
therefore
time to-
we want the instructions. You put it before the budget.
whether it has been put on.
If the amount is included or not, if not, then you put it before the budget. Release this matter on 22nd of February,
22nd.
July,
Yes,
22nd,
22nd.
on which day the Donut State Council, Mr.
You, Sharma.
U. Sarva will obtain instructions in the matter. Mr. Rolosco appears for the report. Yes.
My lord, I am for the petitioner in item number 9 and number 10, my lord, friend is. The matter relates to, my lord, selection and appointment for a post of assistant professor in a college. My lord, where the petitioner is concerned, my lord, they are the governing body and principal, the principal and the college authorities have filed this petition. My lord, there are at least, my lord, 5 or 6 cases filed earlier in respect of this. My lord, may I please a list of these, my lord, for you?
Yes.
There was an advertisement in 2020
Hmm.
for the post of assistant professor. Then, my lord, the petitioner in item number 10, my lord, she filed this repetition for cancel the recommendation of the selection committee to re-advertise the post. And my lord, this honorable court was pleased to set aside the selection, and direction was bring the selection process to its logical conclusion. There was also a matter earlier petition which cannot be very relevant, my lord. Then, my lord, on 27th of February 2003, your lordship, the advertisement was of 2020. Then, my lord, the question number 3 again filed a, my lord, repetition against recommendation on Dr. Brajen Sharma. And, my lord, the repetition was disposed of, and saying that since the director is yet to take any decision, the response number 3 may file a representation. Then, my lord, a hearing took place, and after hearing, the, my lord, director held that Brajen Sharma, his selection was justified. Then, my lord, the response number 3 again filed this petition 46050/2003, assailing this pecking order dated 28/6/2023. The order was set aside on the ground that the publication of the candidates, publications of the candidates were examined by the OSD, and it is not discernible whether DHC conducted the hearing. The Honorable Court remanded back to DHC to take steps strictly in accordance with the directions contained in order of the court dated 27/2/2003. My lord, we will come to that. That will be important, my lord. Then, my lord, DHC again passed a speaking order and directed the selection committee to review the marks obtained by the candidates. Then the principal, my lord, sent all the records. Principal is the petition, one of the petitioners here. Then the review committee, selection committee, my lord, they sent a letter saying that the selection scores were given that on the earlier, my lord, occasion were fully justified. And it also, my lord, refused to consider two documents submitted by the respondent number 3, which were produced at a later date after the interview. Then, my lord, the proceedings of the review meeting, my lord, it recommended Rajan Sharma again, my lord.
No, who are you?
I'm the college
Principal.
principal.
You are
my
the
lord,
secretary of the governing body,
Governing-
or
Yes.
this body which is
my lord, is the secretary.
conducting the selection. How are you agree?
My lord, I am party in all the earlier petitions. I am also party to, my lord, my lord, follow the orders that have been passed by your lordship. In
You are
earlier
not a-
cases.
You are not a candidate,
I am not a candidate, my lord. I want the post to be filled up.
right?
That is my interest, my lord, and it is a 2020 advertisement because of all these litigations and, my lord, wrong orders passed by the, my lord, director. The post could not be filled up. This is in the interest of the students and the college, my lord, the principal and the, my lord, the college authority has come. Now, my lord, finally, the director passed a speaking order. That is, my lord, 6/9/2025. And, my lord, this is on the challenge. Here, my lord, the director hailed the Deepika Borua, that is the respondent number 3, is entitled to 4 marks for her publication. And Rajan Sharma was wrongly awarded 2 marks for his books. And college was asked to rectify the recommendation. Now, your lordship may come to this, my lord, order which has been impugned in the liquidation. That your lordship finds at page 57. I read that.
Yes.
The Honorable Gauhati High Court judgment that is so passed in WPC 4605. Then, my lord, it is to be made clear that the order dated 27/2/2023 passed in WPC 7061 of 2021 had clearly directed the Director of Higher Education Assam to hear the petitioner as well as the principal of Silapathar College, Silapathar, and the respondent number 4, and thereafter pass a final order for appointment of assistant professor in the Department of Assamese in Silapathar College. Point number 8, considering the speaking order dated 26/2023, this court is of the considered opinion that the direction passed by the court in the order dated 27/2023 was not followed by the Director of Higher Education. On this point alone, the speaking order dated 26/2023 stands vitiated. Accordingly, the speaking order dated 26/2023 issued by the Director of Higher Education is set aside and quashed. The matter is now remanded back to the Director of Higher Education Assam to take steps strictly in accordance with the directions passed by the court in the order dated 27/2/2023, passed in WPC 7061 of 2021. We'll read that order later, my lord. Point number 9, let such exercise be taken and completed within the period of 4 weeks. Whereas in compliance with the Honorable High Court judgment and order dated 7/1/2025 in WPC 4605 of 2023, this directorate called a call for a hearing on 13/3/2025, inviting the principal of Silapathar College, respondent number 4, Dr. Rajan Sharma, and the petitioner, Srimati Deepika Borua. During the hearing, Srimati Deepika Borua submitted her relevant statements. Whereas the proposal submitted by the college authority for appointment of Dr. Rajan Sharma to the post of assistant professor in the Department of Assamese, Silapathar College, pursuant to advertisement dated 11/8/2020 has been examined. Whereas the reference is made to the OM dated so, which provides that any selection of the state government job with effect from 8/1/2026 shall debar an employee from applying for any other state level government job in the same position for a maximum period of 3 years. This, my lord, your lordship may skip. The next paragraph, whereas the director has also examined the selection process under government guidelines such and such, relating to the selection of assistant professor librarian in Provincial Colleges of Assam, it is noticed that under clause 2(4) of the said OM, research paper articles in the concerned subject domain published in impact factor journals existing in the database of Scopus Web of Science, Web of Knowledge, 2 marks for each publication subject to a maximum of 4 marks shall be awarded. The petitioner claimed full marks, that is 4 marks for her Scopus publication. However, the selection committee did not award her any marks under this head, thereby recording 0. Since awarding of marks for the publication is a matter concerning subject experts, the directorate deemed it appropriate to seek re-verification by the selection committee. Accordingly, on 23/2025, the committee was called, but due to absence of all members, verification could not be completed. Thereafter, on 18/8/2025, 2 subject experts were deputed to verify the marks in the presence of the undersigned. Upon verification, both experts recommended that Srimati Deepika Buru is entitled to 4 marks for her Scopus in the journal publication and 1 mark for her ISBM publication. Dr. Bhojan Sharma has been wrongly awarded 2 marks under the category ISBM UGC recognized book as per clause such and such of the OM dated 8/11/2018. As such, the final marks of both the candidates differ from the marks originally awarded by the selection committee. In view of the above facts and circumstances, the undersigned deems it fit to remand the matter to the college authority to rectify the proposal of appointment of assistant professor in the Department of Assemblies. You are advertised on 11/8/2020 by duly considering the marks under 2 categories, that is Scopus publication, ISBN publication. The principal syllabus shall submit the rectified proposal to the office of the undersigned within a period of 15 days. Now, my lord, the issue, my lord, that falls for consideration of your lordship, my lord, whether that I have also, my lord, mentioned in the last paragraph of this, my lord.
Selection committee was constituted by whom?
My lord, selection committee has to be constituted under the rules, my lord. And my lord, the subject expert, on which point, my lord, I am urging before your lordship that the director didn't have the authority to, my lord, appoint a subject expert. If your lordship kindly takes up the rules, 2010 rules.
Which rules?
Assam College Employees Provincialization Rules 2010. That your lordship finds, my lord. That's at least 496.
Yes.
Rule 5 is the, my lord, method of recruitment. The rule which sponsors us in this, my lord, proceeding is Rule 10. Selection Committee, Departmental Promotion Committee. Has your lordship got it?
Yes.
A. The committee for selection of candidates for appointment on direct recruitment of lecturers and librarians shall consist of the following: President of the governing body, head of department, 2 nominees of the vice chancellor of the affiliating university, out of whom 1 should be subject expert, secretary of the governing body, 2 subject experts not connected with the college to be nominated by the president of the governing body out of a panel of names approved by the vice chancellor of the affiliating university. 2/3 majority will constitute the quorum. Now, my lord, this is the constitution of the committee. So, my lord, the subject expert must be, my lord, if your lordship sees clause 3, 2 nominees of the vice chancellor of the affiliating university, out of whom 1 should be subject expert. Then, my lord, clause 5, 2 subject experts not connected with the college to be nominated by the president of the governing body out of a panel of names approved by vice chancellor.
Yes.
Now,
So there are 4
my lord,
subject experts.
3, my lord.
Huh?
3
Three.
subjects experts. Nominee of the vice chancellor, 1. Then 2 subject experts.
Either 3 or 4.
I find it 3, my lord. 2 nominees of the, clause 3 is 2 nominees of the university, my lord, vice chancellor, affiliating university, out of whom one should be subject expert. So
Yeah.
1, my lord.
Out of whom one means minimum one should be subject expert. Who can also be subject expert.
Yes, my lord, it can. Then
Yes.
4.
Then
Now, my lord, the director has no authority, my lord, to appoint a, my lord, the subject expert. And here, my lord, the earlier expert committee has given its view. And he has, my lord, engaged 2 subject experts. We do not know the names even, my lord, who are they. And those are, my lord, not the, my lord, nominees of the vice chancellor and the, my lord, nominees of the president of the government. Therefore, my lord, he could not have, my lord, engaged it, and he has considered, because, my lord, the committee, earlier committee, which has also, my lord, reviewed and sent a letter, and they, my lord, said the subsequent documents, those which must have been placed before the director of higher education, those were considered, and the director, my lord, issued direction to consider those and given the marks.
but the selection committee members did not appear before the directorate.
Yes.
Then how is the directorate supposed to pass an order? It appears that the selection committee members refuse to cooperate with the director.
No, my lord, the selection committee, if your lordship kindly sees the order, my lord, at page 55, the communication, my lord, page 55.
55.
55, my lord. This is the proceeding of the review meeting of the selection committee held on 20th March 2025 for selection of candidates for the post of assistant professor in the Department of Assamese, unreserved, Silamathar College, to issue. As per judgment passed by the Honorable Gauhati High Court by case number such and such, and as per the speaking order of the Director of Higher Education Assam by memo number such and such dated 13/3/2025, the review meeting of the selection committee meeting under the chairmanship of Mr. Brodranath Borua, erstwhile President GB Silapathar College, come chairman of the selection committee, was held on 23/2025 at 12 AM at the office of the Director of Higher Education Assam. The following members were present in the review meeting, the review selection committee meeting. The chairman, Brodranath Borua, then member secretary, Alan Pegu, then my lord, subject expert, Purobi Duora, then my lord, HOD, Tulpukan. However, 2 number of VC nominees, namely Professor Subhasana Mohanto Chaudhary, Department of Assembly, Dibrugarh University, Dibrugarh, and Professor Satyakam Borthakur, Department of Assembly, Dibrugarh University, were absent in the review meeting of the selection committee, but they have submitted their report through email. Copy and close. Further, Mr. Biren Borua, one of the subject experts in the selection committee, was also absent, although he was requested to be to attend in the review meeting of the selection committee. However, he has also submitted his opinion through email. The members of the selection committee present in the meeting on 23/2025 verified all the documents submitted earlier to the to select a suitable candidate for the post of assistant professor in the Department of Assembly, Silapatra College, Government Office Memorandum so guidelines, and after threadbare discussion, adopted the following resolution. Resolution number 1. After verification of all documents submitted in support of the candidature of such academic records, research
No,
contribution.
under why was the review meeting held?
My lord, review meeting was held, my lord, because the director on at least 51, my lord, he issued a direction to the selection committee to review the marks. Page 51. A hearing has
Because
been-
of the High Court's order.
A hearing has been conducted in the office chamber of Director of Higher Education Assam on such and such. Heard petitioner so heard principal Silapatra College, heard Bhavin Sharma. Then my next paragraph. Peruse the detailed representation submitted by Deepika Borua as her grievance regarding the mark statement awarded at the time of interview is an academic matter and can be reviewed by the selection committee appointed for the selection process of the said post. Hence, the selection committee is to review the marks awarded during the interview held for the post of assistant professor, Silabatra College. It may be noted here that the review by the selection committee would be done at the office of the Director of Higher Education Assam. Also, the original records of the entire interview process is to be submitted by the principal Silabatra College to the office of the Director of Higher Education. So, as per this, my lord, the review meeting was held in the office of the Director.
But in the absence of the relevant,
Yes, my lord, but they have given their, my lord,
where are their views? The email
be-
reports?
my lord, that will be with the, my lord, Director.
So in the proceedings, which was signed by the member secretary, which is the principal, you refer that these are copies are enclosed with these proceedings. The reports by the email.
If those reports are in the college, my lord, can produce that.
Mr. Chaudhary appears for
the writ petitioner, my lord, in the other case.
who has claimed that the marks were not properly awarded.
Yes.
My lord, from 2020 till date, it's the first time my lord, some order has been passed in favor of the petitioner. But with naked eyes, one can make out whether my lord, I do not know why managing committee is before your lordships. First of all, as your lordships has very rightly pointed out, my learned friend must satisfy where is the governing body resolution that they will move the High Court. The governing body president or the secretary is not their fiefdom, that they'll move whenever they like, because Brajan Sharma is a candidate of his liking. Therefore, he has to be selected at any cost that he will file. Now, my learned friend says for quite some times the post could not be filled up. Why they have obtained a stay order? Now, this stay order is obtaining for the last more than 1 year. They were happy then.
Where is the other candidate who's recommended?
Yes. Now let me place the facts, my lord. First of all, my lord, my humble submission is this writ petition is not maintainable because the governing body has no locus standi. Number one. And number two, my lord, where is the resolution of the governing body which took a call that no, we are going to assail the decision of the director? And kindly similar, director is the appointing authority, not the governing body. As per Rule 7 of 2000, Rule 10, it is the director, my lord, who is the appointing authority. And lordship knows, my lord, indeed there is a concept in administrative law. If a power is given, that power will include all incidental and ancillary power to make the grant complete. Now, if director is the appointing authority, having seen that this matter is being dragged for 6 years, director has appointed 2 subject experts and to find out whether the 4 marks given to Brajan Sharma by these people, whether that is legitimate or not. The expert says it is wrong. The person who is not.
We want to know
Yes.
the other person,
Yes.
other candidate.
Yeah.
Is he also before the court?
Yes, I am the other candidate.
So you are
Of Brajan.
Deepika Bora.
Yes. No, Brajan Sharma is here. In my petition, Brajan Sharma is a party. No.
Is he represented?
Oh. Huh? I said, oh, my lord, in my let me place the facts, my lord. Yes, respondent is a respondent. He's a respondent. No.
No, but he is not assailed the
No.
order
No.
of the director.
No. He is satisfied with the order of the director. Now, my lord, my humble submission is very simple, my lord. The director is the, please have the rules, my lord, for a moment. 496. My first point is this writ petition is not maintainable. The governing body is not the person aggrieved. Who can institute a writ petition? A person who is aggrieved. He is not a writ person aggrieved. Let us be very clear about it. Please come to section 7, rule 10, 7.
Section 7.
Sorry, rule 7 at page 498. All appointment either by direct recruitment or by promotion, shall be made by the director on the basis of recommendation of the governing body, based on recommendation of the selection committee, departmental promotion committee, duly constituted. So, my lord, it is the director who is the appointing authority. Now, here is a matter, my lord. Initially, a lady by name Bidisha Gogoi was appointed. When we filed the writ petition, my lord, when the illegalities were pointed out, then the college itself cancelled the appointment of Bidisha Gogoi. Then, my lord, he was sought to be the selection committee and recommended his name. Then what happened, my lord? We filed this writ petition. Please come to page 49. Please come to page 49, para 6, my lord. The order starts at page 44. A perusal of the speaking order dated 20th of June 23 would indicate that publication of respondent number 4 and the petitioner were examined by OSD of the Directorate of the Higher Education. It is also not discernible as to whether the hearing was conducted by the Director of Higher Education Department as directed by this court by order dated 27 to 23 passed in WPC number so and so. It is to be made clear that order dated 27 to 23 passed in WPC had clearly directed Director of the Higher Education Assam to hear the petitioner as well as principal of the Silapathar College and respondent number 4 and thereafter pass final order of appointment of the assistant professor in the Department of Assamese in Silapathar College. Considering this speaking order dated 26-23, this court is of the considered opinion that direction passed by this court in order dated 27 to 23 was not followed by the Director of Higher Education. On this point alone, speaking order dated 26-23 stands vitiated. Accordingly, speaking order dated so issued by the Director of Higher Education Department is set aside and quashed. Matter is now remanded back to the Director of Higher Education to take steps strictly in accordance with the direction passed by this court in order dated so and so. So, my lord, accordingly,
It is in pursuance to this order, this file hearing was taken.
yes. Now, my lord, the most important part is now what is the wrong which has been committed by the director? Director is the appointing authority. The matter is being dragged for 6 years. The issue is very simple. 4 marks has been given to Brajan Sharma, which is not eligible, and 2 mark was denied to me. And the director appointed 2 subject experts. Well, these are actions. How can it be constituted as arbitrary? And who is governing body to say all these things, Miller? How governing body is agreed? Had it been a matter where Brajan Sharma is agitating, things would have been different. Number one, you do not have locus standi. You are not the person aggrieved. As we all know, Miller, a writ petition can be filed by a person who is aggrieved. The governing body is not, in any case, Miller, there is no governing body resolution. There is no resolution of anybody authorizing the principal to present this writ petition. Merely because writing governing body as petitioner number 1 is nothing. It is the principal who is doing all these things, Miller. Because principal is the ex officio secretary. Now, Lordship has already noticed this impugn order. Please come to page 57. I'll read, my lord, the paragraphs number 1, 2, 3, 4, 5 paragraph from bottom.
Oh.
This sentence at page 57, my lord, the impugn order, which they have challenged, my lord. Whereas this directorate had also examined, has a lawsuit got it done. Whereas this directorate has also examined the selection process under government guideline dated so and so, relating to selection of assistant professor librarian in provincialized colleges of Assam. It is noticed that under clause 2.4 of the OM, research paper article in the concerned subject domain published in Impact Factor journal existing in the database of the Scopus Web of Science, Web of Knowledge, 2 marks for each publication subject to a maximum of 4 marks shall be awarded. Because these 4 marks, Rajan Sharma was not entitled to, which the subject experts have now find out, shall be awarded. The petitioner claims that full marks for her corpus, so and so. However, selection committee did not award her any marks and under this head. So she was entitled to marks, it was not given to her. That's why, my lord, his mark has seen her mark had gone down. Since awarding of mark for publication is a matter concerning the subject expert, this directorate deemed it appropriate to seek re-verification by the selection committee. Accordingly, on 23-25, the committee was called, but due to absence of all members, verification could not be completed. Thereafter, on 18-8-25, 2 subject experts were deputed to verify the marks in presence of the impugn order. Upon verification, both experts recommended that Deepika Bor was entitled to 4 marks for her Scopus Index Journal publication and 1 mark for her ISBN publication. Rajan Sharma has been wrongly awarded 2 marks under category of so-and-so recognized book as per so-and-so. Now, my lord, the contention of my learned friend is that this action of the director is violative of Rule 10. I fail to understand why it is violative of Rule 10. On the contrary, my lord, I'll place 2 judgment of the Supreme Court, my lord. If your lordship should kindly have the Saikari Basu's case, my lord, for a moment. 2008 2 SCC 409. My lord, 2008 to SCC 409. Please come to para 18 at page 414. Just to appreciate, my lord, whether as an appointing authority, director has acted in excess of his jurisdiction.
Paragraph?
Para 41, page 414, para 18. My lord. It is well settled that when power is given to an authority to do something, it includes such incidental or implied power which should ensure proper doing of that thing. In other words, when any power is expressly granted by statute, there is impliedly included in the grant, even without special mention, every power, every control, the denial of which would render the grant itself ineffective. Thus, where an act confers jurisdiction, it impliedly also grants power of doing all such acts or employ such means as are essentially necessary for its execution. But the director, as an appointing authority, why he cannot appoint 2 subject experts to find out whether the selection committee, that the review selection committee on which reliance is placed by the governing body was correctly done or not. Now, the subject expert says that Deepika Bora was denied 4 marks and Rajan Sharma was given 2 marks to which he is not entitled. So, what is the unreasonableness, my lord? What is the irrationality? What is the illegality in such a view of the director that it calls for your lordship's interference? Is it not a power which is implied in the director in Rule 10, Rule 7? Well, another authority on this proposition is, my lord, 1996 1 SCC 642, para 27. That famous LIC's case, my lord, sorry, PLS's case, para 27. Please come to, my lord, Placitum H. In the matter of, has your lordship got it?
Yes.
In the matter of construction of enabling statutes, the principle applicable is that the legislature enables something to be done. It gives power at the same time, by necessary implication, to do everything which is indispensable for the purpose of carrying out the purpose in view. It has been held that power to make a law with respect to any subject carries with it all ancillary and incidental power to make the law effective and workable and to prevent evasion. So, my lord, the director, in my humble submission, has not done any act which goes to the root of the matter. In fact, the director was justified in appointing 2 subject experts to find out what is one. It's a very small matter, my lord. Whether in terms of the government notification of 18/11/2018, marks were given or not. This earlier selection committee members deliberately gave less mark to the petitioner, which is evident. That's why, my lord, when they were called to be present, they were not present. And in the review meeting, they were not personally present. There also, they were in proxy. So, my lord, here is a case. My lord, certainly Lordship is going to dismiss this writ petition that is filed by the principal of the Silapathar College, my lord. He is not aggrieved person, number one. Number two, he has no locus. And secondly, my lord, the order which has been passed by the director is in the interest of justice, my lord. It has been very rightly exercised and it does not call for any interference. So, in the second writ petition, my lord, I have made a prayer to give effect to that order of the director. In the writ petition which I have filed is basically seeking an mandamus to the government, the authority to give effect. And my lord, as an appointing authority, when director has ordered it, they are bound to do it. The moment Lordship vacates the interim order, everything is over. My lord, in a related matter relating to appointment of a grade 3 post, where the same issue, my lord, cropped up, same college, my lord, they have gone by.
They have
They have accepted the
Findings.
director's view in that case. Please come to para 17 of this order, my lord. Section 7 is quoted. Then, my lord, please come to para 20.
yes.
It is well settled that the instance of appointment order by the Director of Higher Education Assam against a vacant sanction post in a provincialized college, that is a public post, in terms of said Rule 2010, Rule 2011, 10 is not an empty formality, as before passing any such order of approval and appointment, Director of Higher Education is required to scrutinize the records of selection, and only after being satisfied, the said authority is required to issue the consequential appointment order. For the reasons above, considering so and so, the court is of the view that claim of the petitioner against selection and appointment of respondent number so and so against the post reserved for so and so is premature one. So here in this case, they have followed Miller. Para 20, in fact, this is what we are arguing, Miller.
Yes.
And Miller, the present petitioner in WPC 23 of 26 was respondent number 6 in this writ petition. Lakshinath Pegu.
Principal.
Yes, 3. 3 and 6 same by name is Lakshinath Pegu. So they somehow wants to stall the appointment of Deepika Murmu. They do not like her face, as it appears. Therefore, my humble submission is, my lord, this writ petition filed by the principal as secretary of the governing body should be dismissed by awarding exemplary cost because they have abused the process of law, my lord. First, number one, the principal can't be an aggrieved person in such a matter because we all know a writ petition can be instituted by an aggrieved person. So, principal cannot be an aggrieved person when the appointing authority issues a directions to be carried out. He cannot be an aggrieved party. When Brajen Sharma has not chosen to contest the proceedings. Number two, my lord, there is no resolution of the governing body to contest this, to file this writ petition. So therefore, it appears the principal has taken personal initiative to stall the appointment of Deepika Murmu. Therefore, my lord, it's a clear attempt to abuse the process of law. Therefore, my lord, this view, a serious view should be taken. And my lord, if your lordship would kindly have this 2001 rules at page number 2001, that management rules of private educational institution, my lord, 437.
437.
Yes, my lord. If your lordship would kindly come to page 442, rule 12, section 12, rule 9, rule. Meeting of governing body. The governing body shall meet at least once in every 4 months, but it may meet at a shorter interval also, if circumstances so demand, and president of the governing body is satisfied that such a meeting is necessary. In this case, incidentally, my lord, president of the governing body is not before your lordships. Then please come to my lord, para 17. Governing body to obtain approval of the director. Then my lord will kindly come to para 18, which is most important. In general, the following are earmarked as duties of governing body in respect of the colleges. Please come to Roman 4, my lord. To appoint persons in connection with the affairs of the college against the post or posts so sanctioned by the state government with scrupulous compliance of the University Grants Commission and state government instructions and policies. If this is the duty of the governing body, my lord, how come they were supporting a candidate who does not deserve to be appointed? So, my lord, governing body is a body which is subordinate to the director. Governing body is in the process of selection. Governing body has a role, but it is the ultimate authority is the director. So when we say who is the appointing authority, it is the director. Now, director finds, based on the views of the subject expert, that the special review which was held is not correct because they have given wrongly marks to Brajan Sharma and denied Deepika Burua 4 marks. Now, once this 4 marks is given, then I become the nominee number 1. So
And
therefore,
this order has been understayed.
understand. This order has been stayed at the instance of the principal. So therefore, my humble submission is, my lord, our writ petition should be allowed, and the writ petition that is 23 of so and so, it should be dismissed with exemplary cause, my lord. It's a clear case of abuse of the process of law. And my lord, the director has not committed any wrong in appointing the subject expert, as in my humble submission, as this is the understanding in an administrative law, that an appointing authority does possess certain implied powers, though it is not clearly given. And in any case, there is nothing to suggest that Rule 10 has been violated. What is there to suggest that Rule 10 has been violated? And who is saying all these things? An interested principal. Therefore, that's my humble submission.
My lord, in the petition filed by Deepika Burua, we have filed a affidavit in order to like to draw your lordship attention to paragraph. Here, my lord, the director has not filed any. Your lordship offered the
Yes.
starts at what? Starts at page 113.
Affidavit in opposition.
Mine.
168. No, which writ petition you saying?
My lord,
Deepika Burua.
7182.
Huh?
7128.
7182. Affidavit on behalf of respondent 5 and 4. 4 and 5.
Yes, 4 and 5. Your lordship may come to under paragraph 7.
7.
That with regard to statements made in paragraph 19 of the writ petition, the answering deponent begs to state that the petitioner has submitted different materials before the Director Higher Education Assam, now at this stage, which were not furnished along with the application form during application for the post of assistant professor of Assamese in the college. The publications relied upon by the petitioner during the time of application for the post of college were, my lord, given the documents, my lord. These documents, my lord, she relied on some other document, last paragraph. As such, she cannot rely on any other publication at a later stage of the submission of application and interview, but during the time of hearing before the Director, Higher Education Assam on 28/3/2023, the petitioner relied on volume 7, issue 4 and volume 7, issue 6, which were not even mentioned in her application form. The petitioner intentionally furnished different materials before the Director Higher Education Assam, which were not even mentioned in her application form. In fact, the article submitted by the petitioner before the Director Higher Education Assam, along with her representation, should not have been considered by the department on this ground itself. Even in the representation dated 6/3/2023, filed by the petitioner before the Director of Higher Education pursuant to the direction of this honorable court, the petitioner has not mentioned anything about the publication relied by her in paragraph 19 of the writ. So, my lord, what she did is some later publication were placed before the Director, and the Director was misled, and it was not pointed out. Now, my lord, so far as the
Was this not pointed out before the Director by
Exactly,
the
not.
college authorities?
my lord, in the my lord, this Director, my lord, passed the order not in presence of the my lord, the college authority.
But then how do you know that this information was wrongly placed
No,
by
my
the
lord,
petitioner?
the question here is, my lord, whether the Director has the power and authority to, my lord, appoint a subject expert.
Okay.
And who are those, my lord, subject
No,
experts?
who's questioning this?
My lord, I am questioning because, my lord,
How are you a person aggrieved?
my lord, my lord, answer that query, my lord. If your lordship kindly sees my writ petition, my lord, in the order dated, the first order, my lord, pursuant to which, my lord, this everything is going on, paragraph page 50, your lordship has already read, my lord, I will only read one paragraph. Paragraph 7, my lord.
Yes.
It is to be made clear that the order dated 27/2/2023 passed in WPC 7061 of 2021 had clearly directed the Director of Higher Education to hear the petitioner as well as the principal of Silapatar College. So, my lord, I am a part of the, my lord, the process. Then, my lord, it was remanded back, my lord, where the certain directions were issued. Now, if your lordship comes to the imperial order, my lord, my learned friend has, my lord, rely on 3 decisions. So far as these decisions, my lord, peerless case and the other case, my lord, it does not say that, my lord, you can violate the rules. Rules are very clear. Rules say, my lord, how the committee is to be constituted and who has to, my lord, appoint the, my lord, subject expert. You bring some persons, my lord, we do not know their names, and, my lord, those persons have given some marks. On the basis of that, my lord, you have decided that one candidate should get, the other should not get these marks.
But the affected party is not before the
My
court.
lord, affected party, my lord, the college authority itself, now one of the direction is issued, my lord,
You
by the authority.
you
Now-
show us, you satisfy the court that you are a person aggrieved.
My lord, my submission before lordship is that, my lord, I ask this question to myself, my lord, when the direction is issued to me and when I know that, my lord, this is against law, my lord, can I shut my eyes and the court, my lord, shut eyes to
We
it, my lord?
want you to enlighten the court with some authorities in support of your contentions.
My lord, my submission is that, my lord, on the face of it, my lord, this order, the exercise, the power exercised by the, my lord, Director is not within this province, my lord. The law does not allow that. And, my lord, on the basis of that, my lord, he calls 2 persons, my lord, and gives some opinion. Some, my lord, so-called experts, my lord, we do not even know the names, my lord. He has not disclosed the names. And I am to carry out that order, my lord. Can I not come with your lordship to say that, my lord, this is a order which is, my lord, in contravention of the rules. My lord, the law of the Supreme Court, my lord, never says that you can violate the rules. So, my lord, the violation is before your lordship, my lord, and I am to carry out that order.
Is it your case that the petitioner in WPC 7182 on the face of it
Well,
is not or does not satisfy the qualification or
My
the
lord,
eligibility criteria?
what I say is that, my lord,
It is a question of allotment of certain marks
my lord,
in respect of certain papers or documents or articles submitted as to whether she should get higher marks or the other person, or which according to the governing body is the other person who has been awarded the higher marks. Is it your case that the director has passed an order permitting the other person, the petitioner in 7182 to be appointed, when on the face of it appears that she is otherwise not qualified, that she does not have the required experience, required degrees, or she does not fulfill the age criteria, anything like that?
my lord, my submission
It's
is
a
very
question
simple,
of
my lord.
it's a question of subjective satisfaction or a decision taken by the director vis-a-vis the decision taken by the governing body.
My lord, my submission before your lordship is that, my lord, the director, my lord, cannot act beyond the rules.
That's what we are asking you.
My lord,
That's what we are asking you. Is it your case that these subject experts are not subject experts as nominated by the governing, the university or persons who are
That is
not
my
otherwise
case.
competent?
That is my case, my lord. That is what I have stated in the petition, my lord.
But you said you don't know the names of these persons.
We do not know the names, but he cannot appoint. My submission is that, my lord, he does not have the authority under the rules, my lord, that he can, my lord, bring in, my lord, subject experts.
So, but the problem is there is a direction by the court that the matter should be revisited by the director and proper hearing has to be taken of all the persons
My
concerned,
lord,
including the governing body.
My lord, the proper course would have been, my lord, for the director to take, even if, my lord, if he is not satisfied with the, my lord, review of the by the earlier committee.
No, but the review also is not as per, it does not reflect that on what basis the review has concluded that the other person has been approved for appointment. On what grounds? You are referring to their reports to the emails.
My lord.
How has this
No, my
reports
lord,
been evaluated?
My lord, they have, my lord, some members have sent by, my lord, email, some, my lord, their
So, but
views.
there has to be a decision taken by the governing body on the basis it has to be evaluated. You are questioning the decision of the director, who's the appointing authority, on the ground that he has no power to appoint subject expert, means that. But if you come back to your own order for review, reading this review order, how do you come to a conclusion that a decision has been taken by evaluating?
Even assuming, my lord, the review committee's report is not acceptable to the director, the proper course would have been, my lord, he ought to have got the names from the university and the college authority, my lord, be approved by the university, and, my lord, give a fresh, my lord, committee, subject expert could have sat, my lord. Because, my lord, he cannot go, my lord, beyond the rules. The proper course would have been, my lord, your lordship may remand it back to the director again, my lord, to follow the procedure. Because, my lord, we are not taking, my lord, sides here. We say that, my lord, the person who is not otherwise, my lord, eligible to be selected, my lord, she is sought to be selected.
No, that's what we are asking you. That's the point. On what basis do you say that she is not eligible to be selected?
Because, my lord, she produced some certain documents based on which the
this information we are asking you from this order at page 57. How have you come to know? Because it does not reflect what documents were produced, what papers were produced.
On the affidavit, we have said, my lord, these
But how did you get this information?
My lord, for that, the records have to be produced.
You are not present.
Records
You are not present. It is your case that the director has passed an order where he is even refused to name the subject experts, let alone not to speak about the documents which you are examining. Where did you get this information?
My lord, because we have the application of the petitioner, my lord, where the documents she has relied, those were there, and in that, my lord, selection also, my lord, the the final order that has been passed, the order impugned here, my lord, the college authority was present, my lord. And what are the documents they have shown that has been, my lord, given specifically in the, my lord, affidavit in opposition?
Yes.
Just 1 minute, Miller. If your lordship should kindly come to page 57 for a moment, Miller.
Yes.
They did not deliberately appear, Miller. Please come to that paragraph, Miller. Since awarding of marks for publication is a matter concerning subject expert, this directorate deemed it fit appropriate to seek re-verification by the selection committee. So, Miller, accordingly, on 23-25, committee was called, but due to absence of all members, verification could not be completed. They did not participate.
What day? The committee, my lord, the selection committee.
Anyway, you have completed, let me do. Thereafter, on 18-8-25, two subject experts were deputed. Now, please come to Millard, page number 55. What is the Millard action of the? Please come to page 54, Millard. These are the two experts, so-called experts, which always appointed. Please come to page 54, last para. Further, the aforementioned observations should be treated as a note for record only and not considered as a negative assessment of selection of so-and-so. We affirm that scores awarded to the candidate during selection committee meeting on 16/9/20 are determined with utmost fairness and in strict compliance with the prevailing office memorandum of government. Therefore, we reiterate our position that scores awarded in the meeting were fully justified and we did not support any alteration. Lastly, owing to our extremely demanding academic schedule, we regret to inform you that we are unable to make a physical visit to your esteemed office at this juncture. However, we remain available for discussion, etc. So, Miller, the experts did not appear. Now they cannot, and in any case, Miller, the principal has got no business to defend these two experts, Miller. The principal will only represent his college. Now, therefore, Miller, the matter is very simple. Director basically wanted to have everybody on the board. When they did not appear, Miller, then two subject experts were appointed. And two subject experts were appointed. And my lord, it is a very incorrect statement to make relying on some appointment. My lord, the selection records are already with the director. Why should the director look to new documents to be produced by me? Why such misleading arguments are being advanced? My lord? All that is, the records are already in the custody of the director. So director just asked this subject expert to go through it and find out whether Rajan Sharma deserves this mark and Deepika Borwa deserves this much of marks or not. When they said, then the director did not issue the appointment order. Now, based on this, director now has said the college, you follow the process as prescribed in routine. So, where is the wrong, Miller?
Yes.
That's all.
Why not some of the principal, the college is represented by the chairman of the government.
No, well, there is no resolution. There is no, in fact, in their affidavit, they say they will produce, but till that they have not produced. In the affidavit, they have said, Miller, they are going to produce the resolution. Till that there is no resolution produced. Paragraph 4 of their reply, Miller, please.
In which writ petition?
Yes,
Filed by the college.
filed by the college. Yes. Paragraph 4, Miller. At page number 176. Huh? Oh, sorry. I'm sorry. Page number 60. 60. Para 4. That with regard to the statement made in paragraph 3A of the affidavit of opposition to dependent denies the same and states that connected writ petition came to be instituted upon a resolution number 1 by governing body of Silapota in its meeting.
You are referring
Millard, affidavit
23 of 23.
Yes.
Then affidavit in?
Affidavit of the college, Millard.
Affidavit of the college.
Yes. Reply.
We leave to produce it, my lord, and now it is here, my lord.
Sounds.
You bring it on record.
Okay, very well, Millard. Now have rule 17, Millard. Yeah,
Rule?
No, this is regarding authorizing the.
No, that also you need approval. Yes. When you're talking of law, then you should speak of law.
I know, basic question is whether your lordship would be.
now
but
basic
I feel, my
question.
lord, violation of. That is my submission, my. The crux of my submission is that.
Now, my lord, 2001 rule, page 443. Any resolution has to have the approval. Governing body to obtain prior approval of the director in certain matters. The minutes of proceedings of the governing body shall be sent to the director and concern affiliating university. Government shall be approved in case. So they have to seek approval.
Rule?
17 of 2001 rules.
Yes.
So equity knows no halfways. If you are relying on a rule, then you will apply with full force. It's not that a part of the rule which helps you will rely on that, and part of the rule which does not follow support you will not rely on that.
You
is
want
not.
to you want to place this document?
If your lordship,
Resolution. Bring it on record. Day after tomorrow. What about the government? Hmm?
Government said we have, I did affidavit also, but one thing, our first contention will be that they have no locus lawsuit. And the director, the only because there's the expert, the director was the order as per compliance of court order also.
Who are the experts? Where did you get the experts?
That information we will not.
Huh?
At present, the exact, at the present, I'm not that information also.
It will be available in your records. We have the records. The records are necessary for this matter.
Then we'll produce the record.
Producing, see, only producing doesn't help. If you're producing it, you should apprise the court that this
No,
is
sir,
what
we
the
have
report
no,
contains.
this is the record here.
Yes.
Sometimes even we'll
Tell us when you can produce it.
some more time.
Give us a date. Monday, Tuesday, Wednesday, Thursday up to Friday. And then again next week from Monday to Friday. Tell us which date is convenient for you.
Give it 2 weeks.
Only for getting the records we have
10
heard
days,
this
10 days.
matter.
10 days.
The next Tuesday.
10 days. 10 days.
It will be more than 10 days.
How about
Yes, next Tuesday, 21st.
22nd?
21st.
21st.
Let it be on 21st.
All right.
Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. Shulko, and Mr. K.N. Chaudhary. M.K. Chaudhary appearing for WPC number 23 of 26. Mr. K.N. Chaudhary, Senior Counsel, assisted by Mr. R.M. Dekka, appearing for WPC number 7182. The learned counsel for the petitioners have addressed the court. Matter required hearing has remained inconclusive. Matter being listed for further hearing on 21st of July. On which date the government council will produce the relevant records relating to the order dated, what's that order? Containing the selection records and the order dated. What is the impugned order? Sixth of
57,
September,
it is 57.
2025. 6th of September, 2025.
Developed.
Right. Schedule. Something. Also small issue, but then requires urgent considerations, my lord, because the medical, my lord, PG examination, the last date is on 21st of this month for submission. And without the registration of the council, my lord, this petitioner would not be able to, my lord, appear for the state exam. The issue involved, my lord, is that this particular petitioner, he is a foreign medical graduate. My lord. There are persons who go abroad and study, my lord, law. Oh, sorry, my lord, study medicine. And she was studying in Ukraine, my lord. The year, my lord, 22-23, after the COVID pandemic, my lord, the Ukraine war had also broken out, my lord. And there were disruptions, my lord, in studies. So in some cases, the students had to come back and complete their courses in an offline mode, or in an online mode from India. And in some cases, the students could go back and complete it subsequently in a offline. The petitioner might not falls in the category that she could go back and complete her course back in the university itself. And in the year 2020, our course is completed, my lord, in offline mode. That is, my lord, certified at page 34. 54. 34, my lord, annexer B. 34. Swati Joshi. It's a full-time student, so and so. During the 12th semester of the 6th year of the university, the student worked out all practical classes and practical training as a physician according to the program. All practical classes were held according to the schedule of educational process. The above mentioned student successfully passed all practical classes and objective structured practical clinical exam offline. So this is a case where the student did not complete it online. She had completed it offline. Now, at that point of time, the National Medical Council might have issued several directives as to how these students are to be treated. There were two categories drawn out, my lord. One, the persons who could not go back and complete it, my lord, offline. They were required, my lord, 2 years clerkship. Additional 2 years upon returning into India, they were to do 2 years clerkship. And for those who completed it online, as required for normal foreign graduates, my lord, only 1 year internship. The petitioner, my lord, along with 6 others, my lord, they were selected for, my lord, offline training. Sorry, internship, my lord. This is at page 36, annexer D. 7 persons, my lord, in the year July 2024. They were deputed for this 1 year internship, and she completed her internship, my lord. Now, after completion of internship, my lord, they have to apply for a permanent registration under the Assam Medical Council. Now, when this application was made, my lord, in August 2025, my lord, the application was not immediately granted, and queries, my lord, were raised with the National Medical Council as to what would be the fate of these persons and how are they to be treated, my lord. Now, because of that reason, it was pending for a long time. We approached this court. Upon some initiative from this court, my lord, the National Medical Council had given a reply, which my lord would find in the affidavit of the respondents. Respondent number 1 had filed an affidavit, my lord. That affidavit at annexer 3, page 73, my lord. Names the petitioner at serial number 1. So the National Medical Commission, my lord, said that the Assam Council would take decisions according to the public notices of 7/12/2023, 19/6/2024, 18/3/2026, and clarification issued on 14/5/2026. Now, their affidavit, my lord, does not contain, my lord, all this
4 circulars. So I filed the additional affidavit, my lord, thereafter, showing that what are the contents of this particular 4, my lord, public notices. So if your lordship comes to my additional affidavit, my lord,
Reply,
affidavit in reply,
yes.
page 85, my lord, is the first notification, my lord. This is concerning those students, my lord, who were affected by war and COVID pandemic, my lord, particularly Ukraine, my lord. So 7/3/2023, my lord, the first clause, it says FMZs means foreign medical graduates, had a break in their final year and returned to India owing to COVID pandemic or war and completed FMC course, including examination through online mode. So this circular, my lord, basically applies to those who had come back to India and completed the course on an online mode, not like the petitioner who had admittedly, my lord, completed it in offline. In those cases, my lord, they have to do 1 year clinical clerkship in lieu of deficiency of their training.
There's nothing about offline.
My lord, as far as offline is concerned, my lord, this clarification subsequently comes because this notice was intended only for persons who had done it, my lord, in a online mode. Now, the next clarification, my lord, comes on page 90, which is 19/6/2024. Continuation of the public notice of event number dated 7 June 2024, it is clarified that all students who have sufficiently compensated the classes in physical on-site in lieu of online classes and subsequently passed equivalent examination to MBBS in India shall be eligible for 1 year mandatory internship as specified in CRMI Regulation 2021. All these conditions will remain, all other conditions will remain as in the notification of 7/12/2023. So it is under this notification, my lord, that I was put for internship. I was not put for clerkship initially. So I completed my internship and I applied for permanent registration. Then 18/3/2026, my lord, there is a further clarification. At page 91. My case actually comes under because for a limited period, my lord, this particular person had to come back when the war was at the peak. Initially, all students, my lord, studying in Ukraine had to
No,
come
what
back.
is your, what do you want now?
My lord, I want my registration to be considered, which is pending, my lord, expressly not yet rejected.
By whom?
By the Assam Medical Council.
Assam Medical
My
Council.
lord, they are the authority. They are the authority to, my lord, grant me the registration.
Why have you not granted?
My lord, our main contention is that, my lord, in the certificate, subsequently we sought for one clarification, my lord. At page 41, that clarification is here. There is another certificate issued by the concerned university, my lord. Page 41. He wrote to the university by page 40, my lord. 40. We sought for some clarification from the university at page 40, my lord.
40.
Yes, 40. With reference to, I am to inform you that the following foreign medical graduate is doing compulsory rotating medical internship at Government Medical College of Assam. So she has completed it. The applicant has submitted certificate from respective medical college, copy of which is enclosed. In this respect, this is for your kind information that National Medical Commission, which is the body authorized by the Government of India for maintaining medical education in the country, has published a public notice dated 20 or referred above for foreign medical graduates, setting rules for them for doing CRMI in India. The relevant section of the public notice is as all students who have sufficiently compensated classes in physical on-site in lieu of online classes and subsequently passed examination equivalent to MBBS in India shall be eligible for 1 year mandatory internship as specified in the CRMI Regulation 2021. I therefore request you to kindly verify and issue a compensation certificate in favor of the applicant certifying that he had sufficiently compensated classes in physical on-site in lieu of the online classes and subsequently pass examination equivalent to MBBS in India. So in response to the letter, my lord, the concerned university has issued the letter at page 41, my lord, wherein they have stated this is to certify that Joshi Swati so graduated from so University on 26/6/2023. Joshi Swati had studied at the Faculty of Training of Foreign Citizens, full-time English language form of education, especially medicine, education at the expense of legal entities individuals. During the period of study, she passed all exams and assessments in all disciplines, obtained the professional qualification physician according to European credit transfer and accumulation system and his diploma in so and supplement is so. During the 2022-23 educational year, the mentioned student compensated all practical classes and practical training which had conducted online during the pandemic and war periods in physical form. The above mentioned students successfully passed all practical classes and the objective structured practical within bracket clinical exam offline. So this certificate, as per our contention, is that, my lord, the certificate doesn't mention anything regarding the theory classes, my lord. They have mentioned only the practical classes, my lord.
Under what provision you are asking for theory classes?
My lord, as per all the notification, not only theory, our contention is that whether she has compensated all the classes or not.
What is the meaning of compensated?
Means, my lord, meaning is that, my lord, if the concerned student was unable to attend the classes and that was conducted online, so subsequently that online classes has to be undergo physically. Yes, my lord. So this certificate doesn't indicate whether the concerned student has compensated the theory classes or not. It is silent regarding the theory classes. Otherwise, my lord, we do not have any objection to issue the registration certificate, but this thing is not clear, my lord.
That query was, my lord, would say, actually not specifically made also. There is no delegation anywhere before that, because when I was put to internship initially, my lord, this query was not made.
What matters is that you have to clear the examination.
Yes.
For clearing the examination, there must be that university will have its own set of procedure.
Yes.
So the certificate mentions that she had cleared all exams and assessments in all disciplines.
In fact, my lord, authorities were also having some confusion. Then they sought for clarification from the NMC. They also did not clarify clearly, my lord.
NMC, as I pointed out in the
NMC
last letter,
ultimately sent the burden on us, my lord.
NMC is a party here.
they are the party man.
Who's representing?
No, my lord. But otherwise, their letter is there in my affidavit, my lord.
The correspondence
That's
made
page
from their
73, my lord. 73.
No,
then-
if you look into the last paragraph,
Yes.
it says during certain such year, mentions a student compensated,
Yes.
which were conducted online.
Yes, my lord. That aspect your lordship may consider, my lord. And in our affidavit, our main contention is that, my lord, that certificate doesn't mention anything about the theory class. That is our only going. In our affidavit also we have stated so,
No,
my
but
lord.
under what provision are you insisting on that? Under what provision are you insisting that or theory classes must also be conducted or their certificate must
Yes,
reflect
that is
the
not-
theory classes? It's not there. The certificate has been issued by the university. It says that she is qualified. Either you reject the
And the petitioner in her reply has categorically stated that, my lord, theory class he has already undergone. There was online classes in respect of the practical classes only.
That aspect only was clarified, my lord. That was the only query put and that was clarified. And Lordship would see one more annexure, my lord. 14 May 2026, which the NMC has referred to, has to be the guiding factor as to the grant of registration.
any other judgments in this regard that you may like to refer to?
No, there is no judgment, madam, because this is something very
Because there are
peculiar,
a
madam.
lot of matters which were before the apex court after
Yes, madam.
the war,
My lord.
and which several orders and directions were issued.
And nothing specifically on the issue of registration, madam, because these circulars are pretty recent, my lord. And the clarification I wanted to point out, my lord, page 96 in my additional affidavit, which the NMC says should be used as a guiding factor.
90?
Page 96, my lord. 14 May 2026. This is addressed to the President of Assam Council of Litigant Registration. Serial number 3, my lord. Serial number 3. Some of the FMGs were allotted 1/2 years internship. I was allotted 1 year internship. The reply, my lord, is that any action taken prior to the issuance of the public notice of 18/3/2026 shall remain unaffected, as the clarification issued on 18/3/2026 shall operate prospectively, and those apply only to those whose application has been received after the issuance of the said notice. Doctors who are undergoing internship as per public notice dated 7/12/2023 and 19/6/2024. I had done under 19/6/2024 because I had completed my course in an offline mode, not in an online mode. In that case, my lord, there should be no variation of the internship that has already been done. So I had done my 1 year internship. Clerkship, my lord, is very clear at 7/3. This 7/12/2023 is the only circular which speaks of additional clerkship. This is only in those cases where persons could not go back to Ukraine and completed the course from India in an online.
Where is that 18/3/26?
18/3/2026, my lord, is there at page
91.
91, my lord.
Where is that earlier 6/3/26?
18/3/26.
No,
Sorry.
18/3.
19/6/24. There are 4 circulars, my lord, which are guiding this.
Where are these circulars?
7 December 2023, page 85. Which I say is applicable only for persons who did not go back to Ukraine and completed the course, my lord.
So online.
Online. Then there comes a clarification, my lord, on 19/6/2024, page 90. Which says that, my lord,
Then comes
those 19/6/2024.
19/6/24.
This applies to persons who go back and then also compensate the classes. So in that case, those persons are to be given 1 year internship. 7 persons, my lord, were along with me, my lord, put for 1 year internship. All others except me, my lord, has been left out.
Probably the petitioner is covered by this notification 1960.
19/6/20. Because under this only I was put for 1 year internship.
Then
18/3/2026, my lord, gives certain clarifications, my lord. Particularly, my lord, there were issues as to what is compensated, my lord, and what is sufficiently compensated. So it means, my lord, at page 94, it says
18/3, there are 2 notifications.
No, my lord, the first page is the forwarding letter. Notification is on page 92. First page is the forwarding letter. In 6, my lord says that you should be compensating the classes, whatever you have missed while coming back to India. So that sufficiently compensated means that the person who has missed classes, my lord, which were conducted in online mode, must be compensated by the foreign medical graduate through physical attendance at the
Where is
parent.
that 6/3/26 is notification, something is superseded?
Six three, my lord, already stood superseded, my lord, therefore probably that is not relevant. And 14 May 2026, I pointed out.
Then 14 May.
14 May 2026, my lord, which is a specific, my lord, reply given to the Assam Medical Council only, because 4 or 5 different cases were pending, my lord, on this aspect.
What is ACMR?
Assam Council for Medical Registration.
Interestingly, my lord, in the first query here also, my lord, the emphasis is on only the practical aspects of the matter, my lord.
Now, under what provision is the registration granted?
This under the, my lord,
NMC.
no, the Assam Medical Registration, my lord, the MRC is the authority, my lord.
And we're asking you what is the procedure? What are the provisions for granting the registration? It must be upon completion of this
For foreign
internship.
foreign medical graduates, my lord, they have to pass one exam upon returning to India, which the petitioner has done, then 1 year internship, then followed by an application for registration, which they have to, my lord, either
So
grant
under
or
what provision
negate.
do you have these? Where are the provisions?
My lord, let me clarify, just give me 1 minute, my lord.
All right, we'll call up after a while. After some time. Ah, you got it.
Yes, my lord. There is one act called Assam Medical Council Act, my lord.
Is it? Where does one get this act?
Yes, my lord. I have got it.
I think it's on 1999.
99.
99.
'99.
Yes, my
99.
lord. 99. Section 15, my lord, says about the registration. Section 15, my lord.
Register of registered practitioners. It's like the Advocates Act, my lord, like registration under the Bar Council. Registration essentially gives me the license to practice.
Then, okay. Section 17, my lord. No, no, no.
So when the clarification is issued, why are you sitting on it?
My lord, actually, we are also confused regarding that term only that I have.
If you're confused, you get your clarification. Why do you want the court to clarify your confusion? You're the authority.
Your lord,
Everything can't be and should not be shifted to the court.
if your
You
lord,
take a decision.
if your lordship clarifies it, then it will be helpful for us.
Where is the need to clarify it when it is
It's
already
otherwise
there?
evident, my lord.
It's already there. Where is the need to clarify it?
NMC also says that these 4 circulars are guiding.
Or you ask your authorities to file an application before the court that you are incapable of taking decisions in these matters.
No, my lord, in our affidavit, that point we have stated that because that particular certificate, compensation certificate doesn't contain the clause regarding completion of the theory classes, my lord. Because it says about the practical classes only.
You write back to the university. Why are you sitting on it? Or you reject the application on that ground? You're not taking any decision.
In fact, they wrote back to the university also, my lord, and asked for clarification, my lord. Annexer M, my lord, case 50, the university again
My lord,
stated
now-
that we have issued the certificate about offline compensation of persons. Then
We are
NMC,
not.
NMC also, my lord, at page 96 in the first query says that we are concerned only about practical aspects of the matter. They don't speak about, my lord, the theoretical aspects which is sought to be raised. There was no question about, my lord, not completing any theoretical. Practical and clinical aspects are all completed, my lord.
And
The
we are
question
not-
of compensation at this stage cannot be reopened, my lord, as per the NMC.
And we are not rejecting, my lord. At page 65, your lordship will find, my lord, what is our conclusion. Page 65, my lord.
Yes.
Last paragraph. Accordingly, after going through all public notices and clarifications published by the NMC in this regard, and since the petitioner had online classes during her final year, Assam Council of Medical Registration is of the opinion that the petitioner shall be eligible for permanent registration only after completion of 1 year clerkship in addition to the 1 year CARMI already completed at TMC. As per public notice dated 20.
What is this 1 year clerkship?
That clerkship, my lord, is mentioned in this annexer R1 85, page 85, 7 December 2023, my lord. This clerkship, my lord, is mandated only for persons who return to India and, my lord, could not complete the course.
Now, what is this clerkship? How does one accomplish this clerkship?
That only they will be. I have not gone through, my lord. I will not be able to explain what exactly
What
is
is
the nature
clerkship?
of duty.
My lord, it is almost like going through 1 year internship course. Internship.
But this CRMI is already there.
Yes, my lord.
Yes. It's already there.
Then
And
where
this
is the 1 year clerkship?
clerkship, my lord, would see at
Provided
page
under-
85. Page 85.
Provided under which?
Notification dated 7/12/2023.
Page 85, my lord.
85, which?
FMCs will have to undergo 1 year clinical clerkship in India in lieu of deficiency in their training from their parent medical. This is applicable again only in those cases where course was completed from India on a online mode and not in the offline mode, like in that case of the petition. So this 7 December is otherwise not applicable. So clerkship is not applicable to. Since I had compensated the classes, my lord, and I had completed it in offline mode by returning back to the university, and the university has been certified, and clarification sought for also has been replied to by the university, and the NMC also says that these 4 circulars will now guide, including the clarification given on 14 May, which says that if somebody has already been assigned a internship, my lord, there will be no variation in the internship period. I have done 1 year internship, then why, my lord, I can be added or burdened with another 1 year of clerkship?
Is there no authority? Where is the NMC? Let us hear the NMC. Who's for NMC?
My lord, D. Buddha.
Please call NMC.
Yes, my lord.
We'll have it 2 then.
Yeah.
For hearing item 13.
Lordship, may I pray for it to be taken up after some time? Right? Your legs. Huh? That also like what will be.
Second up.
It was heard at length on the last occasion also.
Hmm?
This was heard at length at some length at the last occasion. Some additional clarification, my lord, petitioners had sought to put, my lord. But if they're not satisfied as to how there is any dispute as of now to, my lord, seek for appointment of an arbitrator. This is a construction dispute, my lord, between one of the landowner and the
Let him
builder.
after some time.
May I please?
Yeah.
My lord, here the petitioner, he is seeking correction of his parents' name in the HSLC documents, my lord. And his claim was mainly rejected on the ground that his application was time barred. My lord, my parents' actual name, real names are, father's name is Sahidur Rahman and mother's name is Sahera Bibi. Whereas my HSLC documents, my lord, may kindly take my HSLC admit at page number 24, my lord. At page number 24, my lord. This is my HSLC admit card, my lord. Here my name is recorded as candidate's name. It is 5th row. Saiful Islam, that's me. Father's name Sahidul Islam and mother's name Sahara Begum. My father's and mother's name are wrong here.
What is your father's name?
Father's name is Sahidur Rahman.
Sahidur.
Dur. Sahidur Rahman. And mother's name is, real name is Sahera Bibi. Sahera, Sahera Bibi. Bibi. And my lord, in my birth certificate, which is at page number 53. Birth certificate issued by the Joint Director of Health Services. Here my mother's name on the left below my date of birth. Page number 53, my lord. Mother's name is recorded as Sahera Bibi. And on the right hand side, my father's name Sahidur Rahman. Even in my Aadhaar card, my lord, my Aadhaar card is at page number 19. Father's name is recorded as Sahidur Rahman.
When was this issue?
My lord, the birth certificate?
No, this HSLC.
HSLC admit card was issued on page number 24.
Now, where are the provisions that whether time limit is specified?
But as per the specific SEBA rules, it says that 3 years is the limitation, and beyond 3 years it is not permissible. Now, my contention is that, my lord, when I applied my HSLC, I passed in 2016, and my first application was in 2020. So I was beyond 3 years. But when I applied online, there was a provision for late fine. I was allowed to apply, and the late fine was levied on me, and I applied. My first application was dated 22/1/2020. After I did the application, there was no response. When I visited the SEBA office, they said that your application has been rejected. You apply again. My first application, my lord, will find at page number 30. Page number 30, my lord. This is my application dated 22/1/2020. And here at the central portion, my lord, will see I applied for the change in registration. Correct name of father and mother, I say that it should be Sahidul Islam, should be changed to Sahidur Rahman. Sahara Begum should be changed to Sahera Bibi. There was no response. Accordingly, I made second application. My lord, second application is at page number 32. 32. I made second application. Same, I requested that change my father's and mother's name from Sahidul Islam to Sahidur Rahman and Sahara Begum to Sahera Bibi. After that, my mother's name was changed. My mother's name was rectified, and I was issued a new registration certificate, which is at page number 23. Another thing is that the names are sent from the school to SEBA when I am at class 9. And class 9, a registration certificate is issued. After that, in class 10, I get my admit card. Now, my lord, page number 23 is my SEBA registration card. Page number 23. Here, my father's name is Sahidul Islam and mother's name is Sahera Bibi. This is the corrected name, pursuant to my second application for correction of name. And this is issued on 6/12/21. Down below, my lord. Date 6/12/20. So my mother's name has been rectified in the registration card in the year 2021 after 3 years. So definitely correction is allowed after 3 years. But subsequent to that, when I applied for the change in the other documents, admit card, mark sheet, and school living certificate, this is not allowed. It is rejected. Now, after my father's name was not corrected, I preferred a third application. Third application is at page number 34. In the second application, my lord, mother's name is corrected in the registration card. Third application, page number 34, I sought correction in the name of a father only because mother's is already corrected in the registration card. There was no response. It was rejected. Again, they said you go and file another once again. Now I made my fourth application. Fourth application is at page number 36. Now, my lord, prior to the fourth application, the rule is that first correction has to be done in the registration card. After that, the other documents can be corrected. But in the year 2024, as per the information received from the Seva office, rule have changed. All the corrections can be done at one go. Applications can be done at one instance. So,
have you seen their affidavit at page 8, para 8?
Yes, my lord. The specific allegation that has been raised is that I have submitted some document with overwriting. I have tempered.
No, it's a tempered document.
Yes, tempered document. Now, my lord, that document is not placed on record. I need to see the document with what tempering has been done, whether there is some alteration or something.
Yes, ma'am.
You have the record?
Yes,
Yes,
yes.
ma'am.
Show it to him.
What I think, 2005 and 2020. Birth certificate.
I can explain, my lord.
Why two birth certificates is required? Where he applied for the passport, my lord, he did not appear for the verification of the documents. That was rejected by the passport. Then he come to the court, my lord, to correct his father's name. Father's name totally he cannot change, my lord, without any background of the documents. So lordship kindly see this document, my lord. On the basis of that, he has come before your lordships, my lord, to correct his father's name. It is not possible.
The document, the registration number is also.
But he has not mentioned about the overwriting birth certificate.
Where is that overriding?
Which one, Manu? First one.
First one is?
Handwritten, I think, my lord. Something, maybe it's handwritten, I don't know, but it is.
Where is the overwriting from the report?
It is the ballot
By hand.
by hand ballot that has been done. Where is the ballot original certificate? If it is the original certificate, is there ballot, then it is a different thing. This is not a ballot.
No, handwritten where? Which part?
The particulars, all are particulars, names and so and so.
Everything is handwritten.
Handwritten.
Okay.
The
It should not be handwritten.
should not be. The others are by type. What's the other certificates in page number, my lord?
This is issued by which authority? Joint Director.
Joint Director, Health Service.
Submitted.
That was submitted by the petitioner. I don't know from where he is procured. Yes, 53 lordship candidates is the recent birth certificate. Next
Did
page.
you not cross-check it with the health department?
I don't know, my lord. This is submitted to the board, my lord. That's board had verified it, my lord.
No. How has the board verified? That's what we are asking you. How
Oh,
did you verify it?
No, that has been the board has seen, my lord. This is a handwriting, and that is a, my lord.
The board is not a handwriting expert.
No, not handwriting.
Board
expert,
has not issued the certificate.
So
Why have you not cross-checked it
certificate
with
he
the
has
source
submitted.
where the certificate has been issued?
That is the, my lord, the issued by the, my lord, that is the.
So who has given the board the power to come to
Yes. That can be done, my lord.
some kind of a decision on their own whims and fancies? Why have they not gone back to the source?
My lord, that was not done, my lord.
Then?
That can be, my lord. They can ask the issuing authority to submit the, my lord, particular.
You ask your clients to get a certificate and then take it as, tell us whether this particular certificate is genuine or not.
But the petitioner did this ability to
You have rejected on the
Yes,
ground
yes, yes,
saying
sir.
that according to, you have made a averment in your affidavit. It's filed the affidavit.
Secretary.
Secretary, he has made an averment that this is a tempered one.
Yes.
And your only conclusion that it is tempered one is because it is handwritten. And there is no verification with the source from which the certificate is claimed to have been issued. Why not?
They could have done, madam, it is not done. But the handwriting, that the certificate has been for a handwriting, normally it is not handwriting. Page 53, they said, madam, there, madam, all are
Hi,
time.
counsel for the parties, the Mr. T.C. Sutia, Learned Senior Counsel, assisted by Mr. D.K. Roy, appearing for the Board of Secondary Education. Has placed before the court the records in support of the averment made in para 8 of the affidavit filed by the board on 20/02/2025. Para 8 of the affidavit makes the following averments. Expect page number 70. In view of the specific averment that the birth certificate issued on 12/5/2005 was found to be tempered one, the court calls for the records to be placed before the court. Stop. Mr. Sutia submits that the records are available and is placed before the court. Stop. Upon perusal of the document which is found to be tempered one by the board, and on a pointed query made by the court, it is submitted that the document has been found to be tempered because it is handwritten. So, no independent verification with the office issuing the said certificate, namely the Joint Director of Health Services, Kamrup Metro, has been undertaken by the board authorities. Stop. Under such circumstances, it appears that it is the opinion of the board that the certificate is tempered without there being any verification or cross-checking made with the Department of Health. Stop. On the submission made by the counsel for the respondent, we permit 3 weeks' time to the respondents to obtain the views of the health department as to the veracity and genuineness of the birth certificate stated to have been submitted by the petitioner, which is available in the records produced before the court. Is this matter again on 10th of August, on which date? By which date? The board authorities, upon due verification, as directed, upon due verification conducted by the health department as directed to be done by this court, will place the opinion of, will place the views of the health department regarding the veracity and genuineness of these particular document by filing necessary affidavits. Based on 10th. What did you? What did you? This was hard in part. But we release it now because the roster has changed. No? It requires some hearing.
Since your lordship has already heard the matter,
several times.
several times. And in fact, my lord, as per your lordship's direction, on the occasion, the petitioner has filed an additional affidavit. To that effect, we received my lord, our para-wise comment to that effect. But we could not file because without permission of the court, it is required. Because there being certain different aspect in the matter,
You want to file what?
just rejoinder to the
Rejoinder to the rejoinder.
it's not because he brings some new aspect, my lord, without clarification of those aspects, my lord.
My lord, it has been filed on 11/5/2026. 11/5. My learned friend could easily file
My lord,
any
without
rejoinder.
permission of the court, my
No,
lord,
the
definitely we
court
can.
replying something, permission of court is not necessary. As I understand it. And these are all the matter of document, man.
In fact, my lord,
This matter was heard at some length.
My lord, lordship may kindly
before
may not
this
release
court,
the matter.
or pursuant to the permission granted by the court, an additional affidavit has been filed by the petitioner.
On
The
11/5.
learned CGC submits that he would like to bring on record a further affidavit as as according to him, petitioner has placed before the court materials which require response from the respondents. So under such circumstances, we permit the respondents to file their response by way of an additional affidavit, if so advised, within 2 weeks.
a specific date may fix, my lord, they are availing the interim order.
You are asking for filing affidavit.
No, definitely, my lord. Tell you,
If you want, you don't want, it is all right, we'll fix a date. You want to file affidavit or not?
within that fixed date, we'll file it.
All right, within 2 weeks, list on 31st.
Highly.
Matter not to be treated as partner. We're releasing it from partner because the roster has changed, so not properly,
It is continuing since earlier, so I think roster may not affect.
not properly. Once the roster is changed, the further hearing is required. If you can complete it today, then it's a different issue.
Now, we are ready, but my learned friend is raising some.
Releasing from part hard, my lord.
Well,
Since
that's
your
not for
losses
you to decide, it
are
is
the
for me to
material
decide.
land, my lord.
It is
For several days, my lord.
several times.
My lord, sorry, my lord.
The matter will require some hearing. You say that some affidavit is required. That is not being filed. It has to be filed.
Let it be remain with.
No.
Well, no order can be passed on that effect.
No. We are releasing it from partner. If there is a change of bench, it comes again, we'll hear it. Otherwise, it's the same thing. It's on a short issue.
That
Let it remain with real losses, my lord.
Well, that may
Otherwise,
not be
my lord, it will be again, my lord, the opening, my lord.
Yes.
What to do?
Our both parties
Well,
prayer is this one.
That'll, my lord. Let it be remain with real losses, my lord.
No, then we can't give you the liberty to file an affidavit.
Mal, as your losses, please, mal. I cannot, mal.
You
Since
don't
your
want to
losses
file.
hard, I'll place before losses the power was comment,
The
mal.
para-wise things are not necessary.
Well, since they have bring the.
If you want to file, we'll record your submission and pass orders. If you don't want to file, we'll record your submission and pass orders. You make up your mind what submissions you want to make. You want to file it or you don't want to file it?
What we have filed, all are their documents.
Therefore, within a limited scope, the claim made by the petitioner for being considered in the post of Eastern Registrar, which can vacate subsequent to the rearrangement of the percentage reserved for filling up of vacancies between direct recruitment and promotees in the cadre of Western Registrar, and which was during the currency of the select list, the list for recommendation cannot be denied. Whether the petitioner is eligible in terms of the qualifications, which may have been altered by the Board of Governors, is another aspect altogether. Therefore, the respondents will now consider the claim of the petitioner by constituting a review DPC to examine the claims of the petitioner as to whether his claim as a waitlisted candidate in the select list or the list recommended by the DPC is available in terms of the eligibility criteria as it existed then. If the review DPC considers the petitioner's claims are justified, then consequential order shall be passed giving notional benefit to the writ petitioner to the next higher post of Eastern Registrar with effect from the date the vacancy in the post of the Eastern Registrar was identified to be available by the IITG authorities. It is made clear that in terms of the directions of the court for holding a review DPC, if the petitioner is found to be eligible to such benefits, then he shall not be entitled to any arrear or back wages save and except the service benefits of seniority and enhancement in the scale of pay and pensionary benefits as may be available when he demits his office. Review DPC shall be conducted by the respondent authorities, will not affect the promotion already given to the respondent 7, as it was already been discussed above, as since there is no challenge made to the appointment or promotion of the respondent 7 by this writ petition. In terms of the above, writ petitions stand disposed of, interim orders stands merged, pending IAs are also dismissed, directions of the court to reconstitute DPC and pass appropriate orders shall be carried out within 60 days from the date of receipt of certified copy of this order. In the event the petitioner's claims are found to be justified, the review DPC by the review DPC, then consequential order shall be passed by the appointing authority within a further period of 30 days. The records given to the court are returned back to the standing council through the court master. Disposed. Claims made before the court by the petitioner fails and the writ petitions being devoid of any merit, the same is accordingly dismissed. No order is to post, interim orders stand vacated, pending IAs are also dismissed. All the 3 writ petitions. Under such circumstances, court is of the considered view that imposition of punishment or dismissal from service requires interference, and the matter is remanded back to the concerned authority for imposition of any other punishment, major penalty other than dismissal from service, keeping in view the order passed by the competent court towards payment of maintenance to the first wife, namely so and so, and which the petitioner claims he has been making such payments regularly. The respondent authority will examine the matter and pass appropriate orders imposing major penalty other than dismissal from service, entire exercise to be completed within a period of 60 days from the date of receipt of a copy of this order. Writ petition accordingly allowed to the extent indicated, pending IAs are dismissed, interim orders, if any, stand merged. Yes, NMC, what,
I apologize, Lordship, at that moment for not being here, my lord.
that's all right. You are here now.
Lordship.
You take a decision and pass orders on their applications.
Lordship, the decision-making authority here happens to be the respondent number 1 and 2. My lord, why the NMC came into the picture in the instant matter in the first place is that, my lord, with regard to the internship, and as because probably already the learned counsels have already placed before your lordship, that owing to the war and pandemic situation, some unforeseeable circumstances came with regard to certain students as regard to the manner in which they had completed their classes. And with regard to the petitioner and some other queries, Lordship, the respondent authorities number 1 and 2, they had written to the National Medical Commission as to under such circumstances what ought to be done. And my lord, during the pendency of these proceedings only, the reply from NMC had come. I had placed it before this court, as well as my lord, the learned counsel for the petitioner has also brought them on record at page number 96, my lord, in their additional affidavit at page number 96. If I may draw your lordship's attention specifically to page 97 and point number 3, my lord. So these provides the stand of the NMC, my lord, and I've also sought further clarifications that if the mitigating internship or the mitigating classes ought to be done in the manner of the earlier public notices dated 18/3/26 and subsequently, my lord, 7/12/23, which was the first notification with regard to students who fall within the nature of students under which the petitioner also falls. Now, in this light, my lord, from what period she had done the classes, these the respondent state authorities may check and accordingly, my lord, allow or disallow her having a permanent registration, my lord.
So the question is not of the date or whether she has done.
My lord.
The question is that in the certificate, where is the certificate?
841.
841. 41.
Yeah.
This certificate which has been issued by the university, according to the state respondents, does not clarify whether she has undergone theory classes offline.
Theory classes offline, my lord.
Now the question is that a mandate or is that a requirement under the NMC?
My lord, specifically the NMC with regard to completion of classes doesn't go into that depth, my lord, with regard to this. So, my lord, here it would be, my lord, open to the state authorities in terms of the notification.
State authorities are under the NMC. They have to operate under the rules and regulations
Definitely,
of
my
the
lord.
NMC.
Definitely, but
Now the NMC is required to examine or lay down certain criteria that these criteria are fulfilled, that criteria is not fulfilled.
Then, lordship, so as to leave no scope for ambiguity, may I most humbly pray that lordship direct in this order itself that this specific query the NMC addresses within a day or two, my lord, I'll place it before, so that there's no room for ambiguity and my lord, the issue can be addressed.
No, we have already expressed to you. Why should there be a direction by the court?
My lord, then I shall convey it, my lord.
Convey and you get your orders, what is to be done.
Yes, my lord. At this micro level, my lord,
There's no micro level. They see NMC is the authority to decide
my lord,
who will get registration, will not get registration.
my lord.
There are a set of students who went out, they came back, you had a set of rules that, okay, you have a foreign degree, then you must undergo 1 year, 2 year, 3 year, whatever. This training is there, you have to sit for examinations. They've done everything.
My lord.
Now, the only point where the registration is not allowed is because, according to the state authorities, this particular certificate does not clarify that she has attended the theory classes in offline.
My lord. My lord. Practical classes she has compensated.
She has compensated. Now, theory classes, whether compensated, not compensated,
is ambiguous. My lord.
There's an ambiguity. Now, the issue is that theory classes to be compensated would mean that during the period of COVID or the war, while she was here, she had attended some theory classes.
Theory classes.
There is no such objection raised by the respondents also that for this period to that period you were in India or Assam. Therefore, you must have attended
theory classes
online. So, where is the certificate that you have compensated? That is not here. So, on that count, you tell us whether, because according to the writ petitioner, this particular circular which is available, issued by the authorities, This is at page number 85.
Right.
This is in respect of persons who had undertaken courses through online mode.
Right.
This is of 7 December 23. So these are all online mode. She had already completed her courses there.
Right.
Offline and partially online, again compensated, finally got a certificate. Then the second issue is notification is that some earlier notification of 6.3 was there that has been withdrawn and clarifications are issued. Now in this clarification, it is only thing that is relevant is that action taken prior to so and so shall remain unaffected. What is the meaning of that?
Lordship,
Taking a macro view will mean that since she had already completed whatever courses, compensatory classes prior to 18/3/26,
My lord.
she's eligible.
My lord, under such circumstances, it would appear such, my lord.
Oh.
So as to, my lord, as abundant caution, to please your lordship, if I may get the specific instruction
You
with
get
regard
it.
to the theory classes, my
You
lord.
get it.
Lordship may fix a convenient date without for March.
All dates are convenient to us. You tell us what is convenient date for you.
Lordship, 16th or 17th, my lord.
16th or 17th.
My lord, because 21st is the last date for PG admission. Can it? If I don't get the registration.
16th?
16th, my lord.
16th?
16th.
Take only a phone call, bro.
Matter on 16th. Enabling the Standing Council NMC. Mr.
DK Buddha.
Buddha to obtain the required instruction with regard to the eligibility of the commissioner for being registered under the state. What is that? Registration under
Council of Medical
Assam Council of Medical Registration. As the petitioner had already produced a certificate from the foreign university under which she had undergone her medical training. By certificate which was issued on. Is there a date?
10/10/2024.
10/10/2024. In bracket and HRH, page 41. Released again on 16th.
16th.
This is for admissions.
Hello.
You are entitled to make a mention if it is listed below.
Right.
Make a mention at 10:30. Remind the court that this matter needs to be taken up on priority. All right.
Deeply obliged.
Mr. D. Bora or D. Bora for the health department and Mr. Pathak for the. Yes.
Sorry, this better, my lord, I have gone through the records, my lord. Record shows, my lord, he is given ample opportunity to, my lord, to examine his case. It's a minor punishment. It is a personal hearing is not necessary. So he admitted in the reply to the show cause notice, my lord, that, my lord,
There is a judgment pressed into service by petitioners in support of their contention that the opinion of the UPSC
APSC, yes.
or APSC in this case
Yes.
was not furnished and that therefore that is fatal.
My lord, it is not necessary to punish. Opinion is there, my lord.
No, but
records.
have you gone to the judgment?
Judgment, my lord, I have not seen the judgment.
It is there. You have to see and address the court on this judgment. S.N. Narula.
Yes, my lord. My lord, this is a, my lord, a minor punishment as per rules.
Mr. Counsel, this is a judgment of the apex court. It is binding on us. Unless you say on facts, it is distinguishable.
That was not given to. The PSC, my lord,
That was not given. According to you, it is a minor punishment, therefore not necessary.
not that.
But the judgment says otherwise.
Well, also it is a admitted case, my lord. The petitioner has admitted in the so cause notice that my lord reply that a irregularity is committed by him, and he said by doing irregularity, my lord, he does not, my lord, lodge any government executive. Meaning thereby, my lord, he has admitted this case. My lord. The irregularity is there. That's why, my lord, authority has imposed the minor penalty. Doubting his all the his guidelines and rules and regulations, so my lord, he has done it, my lord. And thereafter immediately done it, my lord, he next year, 2012, my lord, he submitted application before the authority to transfer him to any other place. But he was transferred to my lord Gauhati. Immediately after that, during that period, my lord. And had it been a little bit provided to the my lord, petitioner, the opinion of the PSC, my lord, there is more differences. That's why, my lord, his admission lordship kindly see, and deputy commissioner or APDB lordship kindly see.
Posted for delivery of orders on 21st. Mr. Sutia, anything more?
Nothing. My submission is that he was given ample opportunity to display all the documents. When he while writing, he has admitted that I have inspected the document in presence of so and so. And therefore, what remains, Malum? The rules of the Rule 7 also says regarding minor punishment also, there should be given an opportunity to submit his representation, and therefore they will pass an order in case of minor punishment. Had it been a major punishment is a different thing. The second so is required.
So here's a minor punishment, that's why, my lord, my humble submission to lordships, my lord, this GP is, there is no irregularity and my lord, accordingly has passed this appropriate order.
All right. 21st.
Records, my lord, I will.
Hand it over to the court
Yes.
master. The court saying that it will into matter of grading. Doesn't use it. Multiple grading. Huh? Problem no.
One case law I have given, my lord, a partial hearing not happened. He has alleged that he was not given, had his partial
What
hearing.
case? We don't know whatever.
No, I have provided here the records, my lord.
Huh?
Yes, yes, my lord. This one, my lord. That Nirmal Singh, my lord. State of Punjab and Bharat Nirmal Singh. I have given here a small case, my lord. Only one paragraph. With the records, my lord, I have.
For what proposition?
For what I am submitting it in support of that the minor punishment in case, my lord, personal hearing is not necessary.
Respondent. Yes.
I do it. Deeply obliged.
You wanted to place something.
Yes, sir. I wanted to this thing, Lordship. My point is that Lordship is again small submission. I will not take too much time. Lordship, here in this case, as per notice Lordship, which is in number 72, we have named only to till the time when the section as per section 9 petition we got the state, status quo of that property. This is in the section 9 petition, this is also said that yes, we are entitled for this plot of land. They are not supposed to do that plot. Later on, it was being reverted in the appeal court. That is still going on that cases. We are claiming only on that day, Lordship. There, Lordship may mainly go through page number 75. Here, I am claiming the amount 28/1/2024. And next part, Lordship. Inquiry 1 thing, I am only one point, Lordship, that there is a arbitration clause, and that part is not necessarily due to this Office of the Alternative Architecture. That judgment I am relying, Lordship. That here, Lordship, here says that in a nutshell, while exercising power under Section 11 of the 1996 Act, the court has to only examine whether arbitration agreement exists or not. And if it exists, arbitrator has to be appointed who thereafter would decide whether the claims fall within the accepted category or not. The Lordship has inquired.
Where is the agreement which has the arbitration clause?
Lordship, yes, Lordship. Page 27, Lordship.
Yes. According to this agreement.
Yes, Lordship. This is not being disputed by my learned friend also. Other side also, this is not being disputed. Page
So
number.
what is the dispute in this agreement?
Dispute in this agreement is that, Lordship, they have dispute is that any dispute arising out of this shall be mutually resolved by the arbitration only except page number 40.
So what is the in which clause of this agreement, from which clause
Lordship, that
the
part
dispute arises?
here I am saying that, Lordship, there is an my submission is that before your Lordship that there is a I consider that the dispute is there because they have constructed the building next door building without our consent.
You show us from this agreement that this particular clause, according to you, has been violated.
Yes, Lordship. That part Lordship, that dispute is there. Here we have raised the dispute is there. They have, yeah, Lordship. I am saying that they have a dispute because they have made construction over my plot of land.
No, show us from the agreement that there is an agreement you had agreed and they have gone against the clauses of the agreement. That's what we want to see.
Any dispute, Lordship. We are disputing.
Huh?
Here, Lordship, clause number page clause 18, Lordship. They cannot.
18.
Yes. page 34.
Please it.
Yes, second party at the instance of first party having obtained the work of development of adjoining land, that is land measuring so and so, so and so. Here they cannot go beyond this land. This land, the land where they
Please read the clause. Whole clause again. 18.
18, page number 34.
Yes.
The second party at the instance of the first party having obtained the work or development of adjoining land, that is land measuring 1 kotha 18 lesses and 3 kothas 2 lesses covered by Dag number so and so, respectively in patta number so and so, of Pashchim Jalabari in the district of Pamur Assam, and permission for merging the scheduled land as the second party shall give flats to the piece of lands to the said flats in the building to be constructed over the remaining areas after providing 4 numbers of flats. Here also in this agreement, they have stated that while merging the land, they will give us a plot of some flats. Here the main crux of the dispute is that they while constructing the adjoining land, they again use my plot of land, and it is being admitted by the 10th statement also. Here, that is a disputed fact. Here, that part. That part, I mean, in my limited understanding, Lordship, as because there is a arbitration clause, Lordship, and whether dispute is there or not. You to officer architecture of this.
Arbitration clause is born out of an agreement.
Yes.
Now, this agreement says there are certain conditions you'll fulfill, will be applicable amongst the parties.
Yes.
It is only with regard to a particular agreement that in case there is a dispute,
Gotcha.
you'll attempt to resolve it amicably. If not, then refer it to arbitration.
Gotcha.
Right? So you satisfy the court that the dispute which you say arises between you and the respondent is a dispute which arises from this agreement.
Yes, Lordship, because that dispute is because this agreement is of 10 bighas of land, where flats are being already.
We don't know where is the 10 bighas of land here.
Yeah, agreement is schedule is there first. It's 10.7. Total around 10 bighas of land.
10 bighas of land. Schedule.
Schedule is there.
10.72 R.
And another is that Lordship. Total, I think, total will consider. And 16.6 hours, 19.49 hours. So, Lordship, if we boil out if we simplify it, in my understanding, Lordship, there is 10 bighas of land where we have agreed to them use the adjoining land in a separate way, in a separate plot of land. And that part, but now they have used another plot of land without informing us. And for that,
where are these things reflected in the agreement? That's what we are trying to understand for last so many days. You say that there is a dispute.
Yes.
But whether this dispute is premised on this premised out of this agreement.
Yes, Lordship. That part, yes, Lordship. This dispute, if Lordship has to decide whether this dispute is not, I am in the agreement, Lordship. I am using the while going to the section 9 application, the decisions code, they have stated in the initial state because they apply the money. Here, Lordship, my understanding that Lordship, there is, as because in the section 11 application, when we
who has filed the section 9?
Myself.
You filed. What was the order passed?
Initially, a status quo on the construction was put, my lord. There was an arbitration appeal filed, my lord. In the appeal, my lord, that status quo order was, my lord, lifted. So the building construction was completed thereafter.
It is still
and everybody has now already occupied this particular building. Though that arbitration appeal is still pending. Section 37, against the order, my lord, passed by the Honorable District Judge in section 9, that section 37 is pending. Arbitration appeal 2 of 2024, I believe.
Dear Lordship, I have
What was the order given by the appellate court?
Appellate court order, my lord, in one of the additional affidavits, probably I have annexed. It was simply lifting of the status quo, my lord. entry exit to the particular land was stopped, so that was asked to be opened. And that was basically
So
based
what
on
we
a,
want to know is,
Madam.
is it on the ground that,
yes, the question of arbitrability was raised there also.
uh,
That because they had in the
was there any
agreement.
prima facie finding
yes.
by the appellate court that?
No, it is a very short order.
Uh,
Though it was argued and though it was, my lord, otherwise, my lord, reflected in the pleadings, there's nothing such reflected in the arbitration appeal. No, then you can get it. But that is not reflected, my lord.
So we are trying to decide this because of an objection raised by you that
Madam.
matter doesn't require, there is no issue for.
One more thing that
Arbitrator
I'll
to be
just
appointed.
go from
In
my
their
reply.
pleading
right,
lordship,
my
they
lord.
have not said the dispute is there. They have said only a non-arbitrability. They have not said that there is no
Yes,
dispute.
because
They have
it's
admitted
like
that there is a dispute.
like Lordship has correctly pointed out, nothing has arisen
This
out
is-
of this
this is-
particular agreement. Whatever
is-
was their share
But in the
in
long,
this agreement
during the
has
long-
already been given. So if there has been any violation by construction of another building, my lord,
but during the long.
which they say is
litigation-
through their land, my lord, which again is a subject matter because this fourth building we are constructing it through a ZMDA permission. ZMDA permission records that there is a 8.5 foot road available to that. That they have again challenged in a writ petition, my lord, saying that this is illegal. That writ petition is also pending, my lord. So the question of this dispute being an arbitrable dispute, my lord, vis-a-vis this.
Is for the first time also. They have not disputed regarding that. They have only concerned that the issue is non-arbitrable. And this has been decided by the Supreme Court, non-arbitrability.
What is the ground for non-arbitrability?
My lord, firstly, we have said that there is no violation of this particular agreement because this agreement from which they are seeking arbitration has been fully complied by handing over their respective shares as far as the agreement is concerned. Everybody has got their shares. There are specific clauses again in that agreement and also in the power of attorney, which enables us to develop adjoining plots and adjacent and adjoining both plots, my lord. So based on that, we have developed another plot. When we develop that particular plot, they come up initially, one had filed a civil suit, some writ petitions were filed, some FIRs were also filed, saying that this building permission, etc., is all illegal. There's no stay obtained anywhere, my lord, in this matters. But then we come and say that this particular fourth plot, my lord,
This we already have.
Clause 6, lordship.
We already have.
Clause 6 replies his concern, lordship. This has been decided. Non-arbitrability has to be decided by arbitrate time.
No. This is basically why I'm saying so that this dispute now involves the question of whether there is a road, whether this fourth party, the third party, who is, my lord, now the party over which the fourth building has been constructed, they are not a party to this agreement. How can the arbitral tribunal now decide that whether there was a road leading to that particular premises or not, in absence of that particular landowner, my lord, who is not a party to this particular case?
Decided in this particular case, if you come to para 6.
Yes, sir. Yes.
Is whether it is permissible while exercising jurisdiction to hold some claims are non-arbitrable or fall within the accepted category.
Yes.
Here, this is not the issue. Here, the issue is the only claim, whether it is arbitrable or not some claims. Your claim is that there is an agreement, there is a violation of the clauses of the agreement. You have not been able to point out the particular clause.
Regarding third party consideration, that part we can do in the arbitral, while arbitral tribunal is being constituted, there also we have a provision to complete the third party. That is no issue.
Third party, second party will come to that later. You are saying that there is an arbitration agreement.
Yes.
This arbitration agreement is a part of an agreement of development of land between these two parties. this arbitration agreement does not say anything to suggest
Hmm.
that this particular a dispute.
That part, Lordship, may I read, Lordship? Lordship, your permission, Lordship. Clause number 3, Lordship, may I read, Lordship? In a nutshell, the case of appeal inter alia is that while exercising power under Section 11 of 1996 Act, the court has to only examine whether the arbitration agreement exists or not. On if it exists, an arbitrator has to be appointed, who thereafter would decide whether the claims fall within the accepted category or not.
Exactly.
Who arbitration tribunal will decide, Lordship.
No, arbitration tribunal will decide certainly whether the claims are arbitrable or not arbitrable.
No, whether accepted
the-
category or
The
not.
first question is whether there is any dispute that requires the court to refer it to an arbitration.
Lordship, that
You show us that you show us that there is
Lordship,
an authority for that.
Lordship,
Are you saying that the
Lordship dispute,
you-
the Lordship dispute.
are you suggesting that the court under 11.6 is nothing but a post office? That the moment you file an application, refer it to an arbitrator without deciding whether there is a dispute in reality or not.
Lordship dispute.
Whether there is a dispute, where
whether-
is the dispute under the agreement? You have not been able to point out.
Lordship, Lordship,
Tell us that this particular clause they have not complied, or this clause says X, Y, Z, they have not done it. Therefore, there is a dispute. You show us from the agreement.
But I could
Your
point that-
dispute arises over an issue which is not covered by the agreement, for which it is open for you to go and file a suit if you want.
In fact, one of the partners
the
filed
suit
my
is not,
lawsuit.
suit is not.
The suit
this
got
is-
dismissed because my
No,
lord,
no.
it was not properly filed because he was not
lack of
authorized as the partner.
Suit cannot file because it is an unregistered partnership fund.
Even an unregistered partnership can file, partnership firm can file, my lord, if all the partners come together.
No, net also note. 69 bar is there. My friend is there. You are good. You are good.
No, if there is a bar under CPC, are you saying that
Yes, bar is
that
there. 69
there is
bar is
absolutely
there.
no bar under arbitration merely because there is a reference that there disputes will be
No,
resolved
there is,
through
there is,
arbitration.
there is.
First, you have to point out from the agreement that there is indeed a dispute. Whether it is arbitrable or not is a separate issue. Where is the dispute? The respondent said that there is no dispute. They've handed over land, property, everything.
No, Lordship. Their respondents are saying that only arbitrability is not there. Throughout the all pleadings, around 18 suit, around 10 to 11 cases are being filed. Because they have never said that dispute is not there. They have said only the point that this is not arbitrable.
So, but you have not been able to point out the dispute.
Lordship had inquired me whether this is a dispute or not, but I am not being able to make it understandable, Lordship, that whether
From the agreement, you show us that
yes,
the dispute you are raising is covered by the agreement.
I could find that arbitration appeal order.
yes, Lordship. Yeah, dispute. Another dispute is there. May
1 minute. Yes.
Yes, Lordship. I'm just I'm trying to convince Lordship one way, Lordship. Here the main concern is that there is a 10 because of land where we have allowed them to construct the building. Yeah, Lordship. As per clause number 13 of page 15, they have agreed that second party shall raise the multi-story building over the aforesaid plot of land as described in the schedule below as permission obtained by the first party, white number so and so. Here, Lordship, they has to construct that building as per the permission, that permission. Now they have diverted, they have deviated it by showing as a road in between. That part is also a dispute, Lordship. Yet here regarding dispute part, Lordship, which Lordship has raised the question, that part never been raised during the last 5 years. We have lots of litigation, around 10-15 cases have been where we have exchange of pleadings, Lordship. They have only point of contention was that it's non-arbitrable. And I'm in my, my understanding was it non-arbitrable is, this is not a non-arbitrable issue. Then this issue,
Non-arbitrable because there is nothing, my lord, to arbitrate, my lord.
Dear Lordship,
And as far as the court building is concerned, there is an independent permission, has got nothing to do with this particular.
in the notice,
permission.
we have nothing. We
have not violated the building permission that was there with
go
him.
through my notice, claim notice, page number 75.
We have repeatedly asked you to point out from the agreement as to the area where the dispute is there between the parties. This agreement is at page number
Page number 17, 15 to 17. No.
27.
27.
27 onwards.
Right.
Now, from this agreement, you examine and tell us that this particular clause or that particular clause have
Lordship,
been violated.
my only submission is because that any dispute arising out of this, here Lordship, dispute arises now that they have used our land, which I
So dispute, at least we are entitled to know what dispute arises.
dispute because
That
they
you are
have
not
used,
able to.
which I have stated in the
You see, you see, come to clause number 42.
Lordship.
There is a very clear averment.
Yes.
There is a very clear condition. Dispute arising out of this deed.
Yes.
Not any dispute. Dispute arising out of this deed.
Yes.
So you show us that dispute which has arisen out of this deed.
Yes. Yes, Lordship. Yes.
Means under which provision?
Yes, Lordship. That I am stating in the notice. Lordship has to go to the notice part. Notice I am reading from the first Lordship. Notice it is clear, Lordship, from where we are delivering. That on
Why should you take us to the notice without explaining the clauses in the agreement? This is an agreement entered between you and the respondent.
yes, Lordship.
You know what is there in the agreement.
Yes.
Can you not point out that this particular clause says this and that particular
Yes,
clause
Lordship,
says that, and
yes,
that has
Lordship,
not
I
been
am-
complied with?
Yes, Lordship. Clause number 13. Lordship may show, go to the clause number 13 of the agreement. Page 15, Lordship.
Yes.
Page 15. It has been agreed that the second party shall raise the multi-story building over the aforesaid plot of land as described in the schedule below as per permission obtained by the first party, that means us, so and so number. So they have not constructed the building as per the now they have not constructed by allowing the road to go. They are violating this agreement, this permission, GMDA permission of this agreement. Because in GMDA has not allowed, that part has to be, will be decided, this is disputed fact, has to be decided in the tribunal.
Where is the permission of the GMD?
GMDA permission. This one, they have given this configuration. Yeah, Lordship. It is here, Lordship, page number 24. Page 24.
As far as GMD is concerned, my lord, if there is a violation of any statutory norms as far as the permission and plan is concerned, they themselves have the power to, my lord, rectify it. There is a statutory provision in the Act for any building bylaws of building, my lord, permission violation.
This, so this GMJ permission was issued in our name, our company.
That's right, but if there is a violation, you should have raised this objection.
And
Yes,
rather, my lord,
that part is being raised, lordship. Your lordship is inquired whether dispute is there or not.
rather they had, my lord,
Lordship-
executed the deed of declaration with us, my lord, page 34, annexure
This,
R3.
this GMD permission makes no reference about which plot of land,
Your lordship, here,
tag number so and so is there,
yes, lordship.
and 60-meter wide road for residential
Lordship,
apartment.
lordship, the query raised by your lordship,
Uh,
that whether dispute is there or not. Here the dispute is arising out of the deed of agreement because lordship, yes, they have violated while constructing the 10 acres of land. They have constructed the land.
But there has to be a finding that there is indeed some violation.
Lordship, that part will prove in the arbitration.
How will you prove it?
Because
How will the arbitrator prove it unless there is a finding by the authority sanctioning the permission?
no, lordship,
The sanctioning authority
no,
has
lordship, sanctioning authority sanctioning 2011, lordship.
sanctioning authority has to give a finding on inspection
Yes,
that yes, there is some violation of the permission.
yes.
That is a ground for you to raise this question and decide on the compensatory aspect from them.
Lordship, that part we have
Then
here.
You are saying that this is a permission given in your name.
Yes,
You have entered into a contract
Yes.
asking them to construct.
yes, yes.
You say that according to this permission, they have deviated.
Deviated, yes.
Did you bring it to the notice of the sanctioning authority that
Yes, no, lordship, that part is an administrative part. That part will go in the integrated court. That is a separate. Lordship, here, our.
you see, it is not
Our
like
construction-
that because merely because you come to the court and harp on saying that no, there is a dispute
Yes,
without being able to refer to particular areas how the dispute has arisen, and then insist on the court that no, there is a dispute, please refer it to arbitration and let the arbitrator decide it. We can't accept that argument. You have to prima facie show us that this is the agreement, this was what was required to be done by them. There is a dispute, they have refused to do because there is an arbitration agreement. We called upon them, they did not go, therefore we are here.
yeah, lordship, my submission, like this lordship, submitted way, lordship, I leave it to your lordship. My submission is that there is a dispute because we have
Sorry, we have understood your submission that there is a dispute. What we have not been able to understand your submission or what you have not been able to point out is from which clause of the agreement does the dispute arise and why does the dispute arise? Your ground largely is that a dispute arises.
Lordship, here it is.
GMD authorities,
Lordship,
permission has not
here,
been
lordship, section
followed.
as per, yes, because in the notice, lordship, my understanding, in the notice, we have stated what dispute is there, lordship. Lordship is finding that
Where is the notice?
notice is up to lordship 70. It is clearly stated that this is the part cognizance is being taken when notice is being done by lordship. So lordship, in my limited understanding, lordship, at this stage only the arbitral tribunal is the option, lordship. It's up to you, lordship.
No, that is a wrong understanding with all respect. Because you are before a court of law. Are you expecting a court of law to merely accept your submission and pass an order?
No, lordship.
Without you referring how the dispute arises, where it arises?
Lordship, dear lordship,
The question of whether it is arbitrable or not arbitrable is on a different compass. That's a different sector altogether.
yes, lordship.
But at least tell us that the dispute arises from this particular agreement
Lordship,
by violation by the
yes,
writ
lordship,
petitioners,
they have
respondents not following it.
lordship, here, lordship, is because they have used the road, that is the violation, lordship. Because they have stated in the agreement that they will obey the agreement as per they will construct the building as per NOC. But they have not constructed, they have used a road to go there, which they cannot. This is the dispute.
Where have they agreed?
Lordship,
Where is the agreement that they shall not use it as a road?
Yes, definitely, Lordship. Here, the Lordship can go to this number. Just refer, Lordship. Page 15, Lordship. It has been agreed that the second party shall raise the multi-story building over the aforesaid portal as described in the schedule below. So they have agreed that they will construct the building as scheduled below, Lordship. Then there is an agreement, Lordship. Then how can they say they work back now? This is the agreement. This is agreed that the second party shall raise.
Right, my lord, for the disputed building, which they say that now is not constructed, my lord, as per the plan, there is a separate building permission. That building permission, my lord, shows a 8.5 meter.
Where
road,
is
my
it?
lord. Page 89, my lord. 89 of my annexer R11. At that point of time, my lord, this running bases
89.
were not there.
Huh?
Running bases were not there, my lord, at that point of
89.
time. 89.
89 is a part of some affidavit.
See, that will
Now,
also
subsequently, then, my lord, they have put running bases.
that will also
be
vindicate my case.
Annexer R11 of my first affidavit, my lord. This is subsequently. put running
Lordship,
bases.
their permission will vindicate my case.
So
Vindicate
that
my
is-
stand, Lordship. Because in that case, my plan is not.
You arrange your brief according to the running pages. It becomes difficult.
My lord.
There are 2-3 numbers.
In fact, in expeditions.
There are 2-3 numbers here. In some pages, 4 numbers.
The office has done some corrections, my lord, which is not telling with us,
But we'll have to go by these numbers.
my lord. So what why I was pointing out that this particular building permission, my lord, they have challenged in a separate writ petition, 3032 of 2021. There was no stay granted, and therefore the building construction, my lord, was completed. But then that particular writ petition is also still pending, my lord.
Lordship,
So
Right.
different authorities are also involved, my lord, in this issue. As far as my lord, the question of therefore going into arbitration at this stage is concerned, whether GMDA permission at all was violated or not, which they say has been violated, is all subject to some outcome of some repetition as well.
Lordship,
What will the arbitrator, my lord, do at this stage?
dear Lordship, while my friend has referred.
There was one
they refer to
repetition,
their-
my lord, in which, my lord, the
their permission
electricity
will
connection
vindicate
was
my
also
case,
challenged.
That permission will vindicate my case. Because Lordship, that permission is that there is no inkling of the department that they are using, they are allowing
You
them
give
to
us
use.
a status of all the matters which are pending and which are being filed. Give us a status.
I don't have the up-to-date
Give us the
status,
latest status.
my lord, but then I have a list of otherwise the cases,
Day
my
after
lord.
tomorrow.
Lordship, I have some.
Day after.
Chapter 2.
I already have a list, my lord, but then the up-to-date
Then
status I
on
have
next
to just
Tuesday, Lordship, possible, Lordship. Kindly, Lordship.
Okay.
next Tuesday.
So to hear some medical issue right now.
Next week I have to be in, my lord, check.
Lordship, I have some.
23rd.